Good morning, everyone. Welcome to our first day of case call for the month of May, and happy Cinco de Mayo. I don't know if Judges Kelly and O'Brien celebrated as much as perhaps St. Patrick's Day, but since they took Columbus Day away from me, I guess that's the closest I have now to a holiday. We're going to take item number one, case number 376216, Carr versus McDonald. Both parties are endorsed for oral argument. Proceed.
Good morning, Your Honors. May it please this honorable court. Scott Farida, P81855, appearing on behalf of plaintiff appellant Kristen Carr. I would respectfully request that after direct arguments, the balance of my time be reserved for rebuttal if permitted. And Your Honors, I'm not going to simply rehash what's already been filed in this case. I know the court has read everything. What I would like to do is respond to questions that you may have, as well as responding to items raised by the defendant appellee in her filings. There are four main issues before this honorable court. First is whether the action was right for disposition at time of filing. Second is whether the trial court erred in its handling of the sanctions request. Third is whether the records responsive to count 2 were in fact exempt. And finally, 4, whether the dismissal of counts 1, 3, 4, and 5 was premature prior to discovery. I'd like to start with ripeness because that's obviously the prerequisite to the case continuing in any capacity. And this is a fairly straightforward statutory interpretation issue. And there's only two things I would like to emphasize. The first is the importance of looking at the actual statutory language and not the modified version that.
Hang on for a second.
No problem.
Kevin, we have a problem. Judge O'Brien can't hear. Hang on. Let's see if Mr. Wolcott.
Yep. Judge
Bob.
O'Brien, do you have any other apps open on your computer right now that could be taken away from your sound?
She can't hear you.
Yeah, of course you can't hear me. I will try giving her a call.
Okay. Can
Shall I
we're
step
gonna
down?
yeah, just have a seat for a second. I apologize.
Judge Burrell, we have some IT staff who's going to get a hold of her and try to get her situated.
All right, what we'll do is we'll take a break, and we'll come back when the situation gets remedied. Come on up, Judge O'Brien. How are you?
I'm good. Sorry about that.
Oh, that's all right. That wasn't your fault. That was Mike Wolcott's fault. Or Kevin's. I don't know. Blame either one of them. All right, why don't we start from the top? I hate to do that.
Minus the jokes.
Minus the jokes, yeah.
All right. Well, thank you again, Your Honors. Deja vu. My name is Scott Farida. May it please this honorable court, P81855. I'm appearing on behalf of plaintiff appellant Kristen Carr. I'm respectfully requesting that after direct arguments, the balance of my time be reserved for rebuttal. There are four main issues in this case, and I do not intend to simply read off of a brief. I'd like to answer questions the court may have, as well as respond to matters that were raised by the defendant appellee in her filings. The matters at hand are: 1, whether the action was right for disposition at time of filing; 2, whether the trial court erred regarding sanctions. 3, whether the records responsive to count 2 were in fact exempt. And finally, 4, whether the dismissal of counts 1, 3, 4, and 5 were premature prior to discovery. In terms of ripeness, I'd like to address that first because it's the prerequisite for the case proceeding in any capacity, and it's a simple issue of statutory interpretation. So there are only 2 big points I want to make, and the first is to look at the actual plain language of the statute, because the appellee has consistently omitted the second sentence and materially modified the first to fit into an argument that essentially renders nugatory any reference to a time frame. Both the trial court and the appellee's position essentially is that once a response letter is issued, that's all that's required. But the plain language states specifically that if there is an extension on timing, it's during which the public body shall respond to the request. And it's uncontested. There was never a response, nor were any of the emails sent by the plaintiff appellant to the public body, the FOIA coordinator, the chief assistant, as well as corporation counsel ever answered. The only other point I want to make regarding ripeness is there's a lot of extraneous details given in an effort to sort of justify the delay. There's claims that I believe it was the FOIA coordinator didn't have documents available. They had multiple people review. I believe they also label it or characterize it as a complex request. But none of this is relevant to a determination under FOIA as a matter of law. The act does not give carte blanche to a public body to simply extend their response time in perpetuity or any length of time that the body subjectively deems as necessary based on the request. The facts are simple enough. The plaintiff's FOIA requests, all 5 of them, did in fact include the words Freedom of Information Act within the first 250 words. The time frame was not followed, and the action was filed before any response was received from the public body. So if there are questions, I'm happy to answer them, but otherwise I'll move forward in terms of arguments. Seeing on, I'll go to the issue of sanctions. And to be clear, I'm largely going to rely on my brief here. The issue of sanctions is presented in large part to preserve the issue, because much of this is predicated both on the trial court's agreement regarding issues such as ripeness on remand, and some would require further determination by the trial court. One of the things I do want to emphasize, though, is the reason that sanctions were sought. Because reading through the appellee's brief, it seems as though she sort of blurs the lines between what sanctions were actually for. She references arguments that were flushed out in her response to the plaintiff's motion for partial summary disposition and the orders of the court that were based on those arguments. But that's not why sanctions were sought. The motion for sanctions was specific to the defendant's motion for summary disposition, which had the defects such as the misrepresentation regarding ripeness, the statutory language, the Gilman opinion, and things of that nature. So when we're analyzing whether the trial court, actually considered all of the claims and all the legal arguments, where it seems like the focus was entirely sanctions pursuant to FOIA, and B, whether or not the trial court reached the right conclusion, it's important to not look at all of the additional filings or arguments that had been put in a later point in time, but rather why were sanctions sought? Because that brief, the contents of it, the burden, don't just get placed on the opposing party, don't just get washed away because at a later point in time further arguments are made. So that brings us to issue 3, which is where we start to really get to the meat of the case, and that is the exemptions. This is only applicable to count 2. Count 2 is the only item for which the public body agrees that there are records that were not turned over, but asserts that there is an exemption applicable to each and every one of them. And there's a 3-letter word that applies to each and every one of the exemptions and the arguments put forth by the appellee, and that's how. How would a single thing that the public body states will come to pass actually occur if the records are released? And this is important because our Supreme Court has been very clear that, and this is from Evening News Association, which is a case from which the rules that are required were actually cited by the appellee. But this is number 5. Justification of exemptions must be more than conclusory. Justification must indicate factually how. And number 6 is actually even more devastating to their position because the mere showing of a direct relationship between records sought and an investigation is inadequate. Throughout all of the proceedings, but the filings before this court, those of the trial court, there is never a single explanation as to how any of these issues would arise if the records are released. There's a claim, for instance, that the release of the records would endanger a member of the public body. Again, how? It's not a rhetorical question. It's an important question because if in fact it's something as benign as one of the people making a threat included in the home address of the elected prosecutor, they got a hold of it. That's an easy redaction. And the public body must separate the exempt from unexempt. Time and time again, you see the words particularized justification. They appear before the filings before this court and the lower court, and that is not enough. To merely say we are asserting this exemption because, in essence, because it applies, because harm would result is not enough. That is conclusory. That provides no meaningful or substantive explanation whatsoever. And fundamentally, the problem is, too, the approach taken by both the trial court and the appellee. Each and every one of these documents was treated almost if they were conjoined. They were a monolith, that it was just an all or none situation. The public body never stated even how many of these there were. There was no breakdown. There was no review by the trial court, no request for a bill of particulars. It all was treated as fundamentally, well, these are all exempt and that's it. The interesting thing as well is that the trial court didn't seem to actually make a decision based on the facts. It was a matter of law. The opinion in order references the fact that a threat against a member of a public body in their capacity is a crime, and therefore, in essence, the exemption resulted. But I go back to Rule 6. Even if there was an investigation ongoing, which I'll get into in a moment, it cannot be merely, well, there's an investigation. There has to be how. There has to be an explanation as to what the interference may be. The burden, of course, is on the public body to sustain their objection, so it's not the plaintiff's burden to overcome and explain to the court. And based on the opinion of the trial court, it seemed as though the public body was just given deference. The short, anemic affidavit of the chief assistant was the only thing provided. There's not a single affidavit from any member of law enforcement or any entity supposedly actually investigating these. And I want to be very clear. My client never sought police reports, warrant applications, warrant denials, communications by a public body. And that's important because if you look at page
What
10,
exactly does your client want on this?
in regards to this, Your Honor, it will count to as all documented threats of violence or harm against defendant, her family, and or the prosecutor's office made via email, writing, electronically, etc. between November 20th of 2021 and June 25th of 2024. And I would note that on page 10 of the opinion in
Tell
order.
me what, hang on,
Yes.
take a breath.
Sorry, Your Honor.
Tell me why that's discoverable under FOIA.
Because the Freedom of Information Act states specifically that unless a record is specifically exempted, then it is discoverable. The exemptions that were submitted, I will address you and why first briefly, because those are
That's
just,
what I asked, okay?
well,
What I asked was a very simple question and you answered it.
Okay.
That's good.
Thank you, Your Honor. The point I wanted to make as well regarding the opinion and order of the court is there seems to also be an error in the analysis because on page 10, the trial court, despite in the preliminary section actually quoting the exemption, in the analysis, she states that that the records did qualify under the exemption because the client was, quote, seeking all records about the threats. That is much, much broader than the threats themselves. If it was that request, that would implicate things like police reports and the like, but that was not the request. So it seems that as though the trial court, part of the opinion was based on a misreading or misinterpretation of what the request actually was. And the problem as well.
So your client wants all of the threats that were sent to the prosecutor's office for a specific time frame. And that's it, correct?
Yes, Your Honor. And I would note as well, too, that the trial court was actually presented evidence that not all of what is being classified as threats are threats of violence, which would be criminal in nature. A police report from the Oakland County Sheriff's Office was presented to the trial court, as well as this body, in which the affiant actually had previously gone to them with a flash drive and said there are recordings of threats against Karen McDonald. I want them investigated. And this is a short quote from that police report.
We don't need it.
Okay.
Move on.
So, Your Honors, regarding and I would note as well, too, that in addition to not producing any affidavit or evidence from an entity investigating, explaining, that there is an investigation for specific threats, not just, again, treating them all the same, There's also no evidence that,
Well, but that's what that's what your client asked. She asked for all the threats
Yep.
between this time frame.
but that does not mean that all the threats are of the same quality and nature. Just because one threat could potentially either have a partial exemption or full exemption does not mean that every single document that could potentially be responsive is exempt. Again, FOIA states.
Sounds to me like something that would be best suited for an in-camera review, assuming that it's discoverable.
I would not oppose that, Your Honor, nor disagree. If there's a question as to what the contents are and whether they actually would interfere or would endanger a party, then the trial court could make a review, or there could be a bill of particulars providing an explanation. There are options that were available that just were not taken, and the authority regarding those options was in fact presented to the trial court. And in regards to the exemptions generally, I would just end by stating that this, actually, I don't want to sound like a broken record, but just will end by emphasizing.
Oh, that ship sailed.
All right, well, I'll just end this point by saying that, again, the burden is on the public body to sustain the objections, and there was not an actual substantive explanation as to the how.
What was the trial court's ruling referencing the? I don't have a problem with most of what you do, but when you're getting into things such as threats and things like this, it just seems to me that we're operating outside of the parameters of FOIA, and that if I were hearing this as a trial judge, I probably would have ruled the same way. First of all, I don't think this is what the legislature intended. Now, in our discussions about this case, I would have no problem if your client had said, send me all invoices of contracts that the office has for security measures. But getting into specific security threats, I think that's a dangerous precedent. And certainly one that as judges who we are subjected constantly to threats, as our prosecutors and police officers and anybody else in the criminal justice system or in the justice system, kind of hits close to home. So I'm curious as to what your direct response is to the trial court's findings relative to these threats, that they were not encompassed within the act.
I'm trying to think the best way to describe it, because some of these threats were not threats of harm. So I referenced the police report. It was a threat to
But you
reputation.
didn't make a delineation, your client didn't make a delineation between just what you're calling threats and then threats of harm. I guess I'm trying to understand, how could a threat be a threat but not be a threat of harm? What would it be a threat of? I'm gonna burn your steak?
I believe this is where the miscommunication is coming in. The exemption is not for threats. It's that the release of the record would endanger a member of the public. If the individual who is threatened or her agents have specifically to the public stated they were threatened and described the nature of the threats, what is the substantive difference between members of the public reading them? I would agree if the public body could articulate that there was something specific in a threat that would endanger them. For instance, if someone had gotten a hold of
Isn't that the nature of a threat? The
No.
purpose of a threat is to put someone in danger, is it not?
The purpose of a threat is to threaten. It's to make them uncomfortable. It's funny. You stated
Put them in danger.
this is anecdotal, but you've mentioned specifically prosecutors. And during oral arguments before the trial court, the appellee side stated that Mr. Farida, myself, had worked for the Oakland County Prosecutor's Office. I should be sensitive to the nature of threats and things of that nature. I specifically told the trial court I was threatened. In that case, there was never any investigation. There was never followed through with security measures. The mere fact a threat is made does not inherently mean there's an investigation, or does not inherently mean that if someone merely knows about the existence of the threat or the content, that the person is in harm. The mere fact I was threatened does not mean that if someone knew I was threatened, I had any form of additional harm. The person who made the threat is the individual who would potentially be a dangerous individual. They are the one who wants to act. A member of the public reading something that says, I'm going to get you. I'm going to, as you said,
What
burn your
if the
house.
nature of the threat is of a highly personal nature? for example, what if unbeknownst to the public as a whole, I have a special needs child who goes to a school and I receive a threat that says, I know your son is so-and-so and blah, blah, blah. What, do you think that's exempted from FOIA or not?
Yes, but for a different exemption. I believe exemption A is privacy, in which things being released that would be of a personal and embarrassing nature would encompass. That was never asserted. That's why I make the point that there's no there's no exemption that broadly applies to all threats. We have to look at the specific exemptions and the claims, because that would be a scenario. There could be a multitude of different things where different exemptions were invoked, but that was not the claim of the public body. The public body merely stated, if anyone sees these, the prosecutor will be endangered. Again, I go back to how does someone reading something that the head of the public body has already said happened and already described the quality and nature do anything to change the facts? The facts are that a person, a member of the public, made a threat. That individual expressed a desire for harm. There's nothing further that would go from there. If there was something like you gave as an example, or again, the example I gave, which is a home address, that could be exempted out. That could be simply removed through the magic of Adobe. The reason I keep hammering this point is specifically, again, because of what our Supreme Court said in Rule 6. Even if we're saying that there's an investigation, which for the threats that were not threats of harm, but threats to reputation, that is not merely enough. There has to be a causal relationship. There cannot be simply a statement that we've particularized our justification, we say this will happen, and that's it. What is the connective tissue between point A, where we are now, and point C, where we'll be per what the public body asserts? That's the proper analysis. And Your Honor, you made a good point again. If there was an in-camera review and the court specifically went through and raised something like you said, this is very specific to a personal part of the family, or, well, there's a home address here, we have to take this out. Or if the court had ordered a bill of particulars, which our Supreme Court has stated in Rule 5 is permissible, say, okay, what exactly is your concern? But the public body just said, no, they're intrinsically linked. We can't do anything about it. That's it, without any explanation. I'll go back to the fact that the public body did not even give the number of threats. We don't know if we're talking about 500 or 700. We know nothing more than just a broad statement, hey, there was a threat. I'll end by the point, too, that the oral arguments were held in 25. The case that was charged, that Ms. McDonald asserts that was the triggering point for her getting threats, was charged in 2021. I'm not aware of a single person ever being charged, nor am I, and we're running up, frankly, on the statute of limitations. So to assert broadly that, oh, there are all these investigations, even though there's no evidence of them, and the report from the sheriff's office, again, indicates they weren't proceeding, at least as it relates to threats to reputation, that's a problem for the public body.
I have one additional question, and that's it. The person who answered this, Williams,
Yes.
That's the chief assistant?
Yes, Your Honor.
And why is he the FOIA? Does Oakland County, to your knowledge, have a FOIA? I imagine they must.
Oakland County has two FOIAs. They have a FOIA portal for the whole county, and for whatever reason, the prosecutor's office has their own FOIA portal. They have their own FOIA coordinator, who in this case, I believe, sent the initial extension letters. I would have to review to make sure.
That's all right.
Okay. And Miss,
How long have they had the two?
from back when I even worked in the office, starting in 17, they had that. I'm not aware they've had a time where it wasn't separate. So
is Williams the designated FOIA? I know, I think I asked this, he's not the designated FOIA person for the prosecutor, or he is? I'm not.
As far as I know, no. And that was the one note about him as well, is this goes to the personal knowledge issue. It seems like there would be a conflict if he was personally handling the prosecutions where his boss is the alleged victim, which is why I emphasize the need to have something from an actual law enforcement agency, because all he said is, oh, I've reviewed records. So, but before I move on, because I want to make sure I've answered a question, is there any more questions regarding the exemptions? All right, hearing none, I'll move into the issue of the dismissal. So in relation to counts 1, 3, 4, and 5, the assertion of the public body was that there are no further records. For count 1, they said there are no records. For the remaining counts, they stated we've produced all the records. And there are a few interesting things to point out. The first is before this court, the appellee for the first time asserts that discovery was waived. She makes the argument unpreserved that discovery was never sought and therefore it should not be considered. But there are a few problems there. First off, the appellee doesn't actually get into the law on point. To give you an example, she complains that initial disclosures weren't made. All right, well, the remedy for that is set forth in MCR 2.313A2A, which asserts that you file a motion to compel. The mere fact that initial disclosures weren't made, particularly when it was the initial stages of summary disposition, does not inherently mean that discovery is permanently barred and the case simply cannot proceed. So it's not only an unpreserved issue, but it's a bit of an overblown presentation in terms of that regard. And it's a bit disingenuous too, because the entire argument before the trial court was specifically that the case for these counts should proceed to discovery. The legal standard was set forth, the explanation of the operative question being whether further discovery stood a fair chance of uncovering factual support. My client complied with the court rules. Not only was an affidavit submitted in which she set forth her personal knowledge, there were sections of that regarding unavailability of witnesses in which she identified specific witnesses that would have personal knowledge, but are agents of the defendant and thus unavailable. Fundamentally, that was the argument presented to the trial court in its entirety. And we also, too, went through for each and every one of these counts and explained why additional records did in fact exist or why they should exist. It was not idle speculation. This is the most explicit as to count 5, because the trial court was presented two different things that were very, very blatant. One was an invoice from a PR company that no contract had been provided. But the second is without the benefit of discovery. In the immediate lead up to the hearing, we became aware of a Board of Commissioners report for the Oakland County Finance Committee that specifically listed out 5 prosecutor PR contracts. And those contracts, and this is in was presented in oral arguments and the transcript was excised for this hearing. We cross-referenced the contract numbers for what was provided, and they did not match any of those. In fact, the contract discovered after the fact also does not match any of those. So the trial court had in its possession an invoice from a company with no contract, and we explained a Board of Commissioners report, an actual document from the public body listing out additional contracts that didn't match. And yet the trial court gave complete and utter deference to the public body, stated, well, their affidavit says there's nothing else and that's it. And that fundamentally, again, is not the question. The question is whether discovery stood a fair probability of supporting Ms. Carr's position, which when we've broken down specifically for each and every count why additional records should in fact exist, then that is what should have been applied when the trial court was making its decision. Another aspect of this as well is that in regards to those contracts, even now, there's no explanation as to how we've uncovered an additional contract that was not turned over when Mr. Williams supposedly had personal knowledge and asserted, nope, there's absolutely nothing else. And I don't want to be hyperbolic, but if there's no meaningful right to discovery in a FOIA case, the act is largely gutted. All you need is a member of the public body willing to sign an affidavit saying there's nothing. And what's the recourse? You don't have a hearing. So the risk level is at the floor because you wouldn't even hold them before the court to address anything. And the odds of actually discovering additional records themselves are very low. It is extremely difficult to disprove a negative. And sometimes it's by pure happenstance that you might become aware of it.
Was discovery going on during this period?
No, Your Honors. It is initially, so every judge in Oakland County recused themselves. And by the time we got an assignment of a court, a scheduling order had been issued seemingly just automatically by the court system, and everything was stale. The parties both agreed to set it aside. The parties both agreed that we were filing motions for summary disposition. We agreed to dates. The court issued a new briefing out or a new scheduling order, which set forth by which point our briefs had to be filed and been heard. And so at that point, given the public body was seeking dismissal of the entire action, there's no point in proceeding in that regard. There's case law about how high-ranking members of a public body cannot be hauled in for certain discovery items because of how unduly burdensome it would be. Until the trial court decided, okay, these are still the issues that are left on the table for you to decide to deal with, the procedural posture was we needed to get through summary disposition. If we didn't get...
You were never able to send a request to produce or a subpoena to PR identity PR? Because presumably if there's a contract, they'd have a copy of it too, correct?
Sorry, I didn't hear the first part of the question. The second part I heard was about a subpoena to identity PR.
You never got that far to request that or request to produce?
No, Your
Because
Honors.
presumably if there was a contract with identity PR to pay their invoice of $35,893.25, they would have a copy of the contract too.
I agree with you, Your Honor.
Yeah.
The reason it didn't is, again, the procedural status of the case. Frankly, so any motion obviously has a bare minimum of 7 days notice for the motion to be heard from the filing date. If you consider it, and I did not anticipate the amount of time that the trial court would end up using to issue its order, but if you consider the amount of time elapsing, we're potentially hauling in third parties at this point, for your example, and high-ranking members of a public body on issues that the court may dismiss and decline to hear, which in this case, the court made a determination regarding ripeness, which is the whole kit and caboodle. Every person has the right to object to discovery as being unduly burdensome, and I don't know how we could have got around that. For a third party to say, you are hauling us in and making us participate when this case might be
No,
dismissed.
This hauling in, there's
Yeah.
something that bothers me a great deal about this case, which is we're talking about a contract.
Yes.
I mean, I work for the government in the state of Michigan. If I were to ask our finance guy to produce a contract for Mr. Scott's security firm, I bet I would have it within 10 minutes. And
Couldn't
yet we're
agree with
talking
you.
about dragging people in and searching records. I don't know, what's so hard about pulling out a piece of paper with a contract?
I agree.
don't- What am I missing here? That's so difficult to produce a contract.
That is a better question for the public body. I provided, not initially an email, I just
You
had.
have 2 minutes.
All right. I'll just end by saying this. I provided the Board of Commissioners report cover page and those contract numbers. They've never been provided. I don't know what the issue was, but I would respectfully request to reserve my last, now about a minute for rebuttal if the court would permit. Thank you, Your Honors.
Good morning, Your Honor. May it please the court, Benjamin Aloya on behalf of the appellee, Karen McDonald. I'd like to just address the arguments as they were presented by the appellant. First, I think it's important to note that the court did not dismiss the case based on a ripeness argument. It substantively reviewed each and every response that was made by the prosecutor's office. It implemented the 6-rule standard and made a substantive decision under its de novo review and applied the appropriate standards in order to dismiss the case. The ripeness argument really only came into effect when the appellant requested sanctions. While the court did mention that it did not believe it was ripe, the fact of the matter is the court did make a substantive determination on sanctions in its opinion and said that she did not believe that the appellant was entitled to an award of sanctions. The court pointed out that there were significant defenses raised to the claims and that it was Ms. McDonald was successful on her motion for summary disposition. When addressing the delay and the 10-day note past the 10-day extension, the court did opine and looked into whether it was willful and intentional, which is part of the statute. And the court reviewed the information and determined it was not a willful and intentional determination substantively. So the ripeness argument really didn't come into play in the court's ultimate determinations, either on the substantive claims or on sanctions, Your Honor. As to the second request, which has to do with the threats against the Oakland County Prosecutor's Office, it should go without saying that Karen McDonald is the Oakland County Prosecutor. She is the chief law enforcement officer. Any documents that would be maintained by the Oakland County Prosecutor's Office would be for the purpose of law enforcement and investigation.
Not necessarily.
In this instance, yes, Your Honor.
Why?
Because those were documented threats against the Oakland County Prosecutor, and those were in fact investigated as we've raised by the exemption defense.
All of them?
Yes, Your Honor.
Your statement to this court is that every threat that was ever received in that time frame that's under review by this court, every one of those was investigated and subjected to a police investigation?
Based on the information that I have, Your Honor. I mean, Ms. McDonald does have investigators within the Oakland County Prosecutor's Office. There was a sheriff's department. Some people were prosecuted. So yes, there were investigations. And this is a highly sensitive situation, Your Honor. This was during the time when the the Oxford shooting was going on, the Crumley prosecutions were going on. So it's a highly sensitive time, Your Honor. And due to those threats, as the appellant knows,
That
because
doesn't change your client's, the situation, as you put it, doesn't change your client's legal obligations under FOIA, does it?
it doesn't, Your Honor, but we've raised a
Well, why would we raise it? If it doesn't have any effect on the FOIA obligations of your client, what difference does it make?
Well, the presumption is that the public record would be disclosable unless it falls under an exemption. And we identified the exemption with a particularized justification.
You know, you had conclusions and Evening News says you need facts.
Well,
You didn't have that, did you?
through the analysis and through the motions, we've identified what the issue was. And in fact, it's known to the appellant. And he's received information. She has received security detail as a result of these threats. There are security measures and implementations that have put in place. There have been dollars spent in order to give her personal security detail during this time. And it comes into,
Would you agree with me that if there is a contract for security for your client, that the public has a right to that information? Not to how the security firm operates, but simply to a contract that the prosecutor may have regarding how much it is spending on her security?
as to the Fortis situation, which was the first request, the contract didn't exist, Your Honor. In the Oakland County Prosecutor's Office, they received POs. Those POs were produced to Mr. Farida, but there was not a signed contract with that security detail. My understanding was due to the hastiness of getting them implemented. So he has all the invoices. He knows what was spent. He knows what was paid for. There just wasn't a contract to produce.
But my question was, if there was a contract, would you agree that it's discoverable under FOIA and that your client would have an affirmative obligation to produce it?
Yes, so long as there wasn't any particularized information within it, which would compromise the security and safety of Ms. McDonald. And in those cases, only particularized information could be redacted, but the contract would be produced. Yes, but it doesn't exist, Your Honor. And there was a search and there was a firm understanding that at that time, a contract was not signed. There were POs presented and those were presented to the county for.
Is that the same with Identity PR?
So the issue with Identity PR is the same, is that the prosecutor's office had invoices. They did not have contracts. The contract that he's alluding to.
I have to interrupt you because it strikes me as a bit odd that a municipal corporation such as Oakland County or the Oakland County Prosecutor's Office sends checks to companies but doesn't have contracts with them. I've never heard of that occurring with a municipal corporation. How does that work exactly?
It's a very good question, Your Honor, and it's something that I question. I was told due to the hastiness of the situation that
Hastiness for security, that's one thing, but hastiness for a PR firm? I mean, what's the rush?
This just
And
isn't adding
36,
up.
yeah, it doesn't, something is
So-
very wrong here.
So the contract that he's alluding to is a document that he's attached, is a document which was part of the purchasing department's protocol. It's not necessarily signed by the Moment Identity or whatever that company is. It's a purchasing department document. But that's the way that this was facilitated. Whether it was right or wrong, we have looked through the documents. There is no contract. As you see, like he asked for a contract with the Washington Post. So the contract was simply a letter that was like signed at the bottom by the individual from the Washington Post. The Hulu agreement was not a contract. It was simply a document like a memorandum of understanding that was sent. It was not a formal document. Is that the best practice? Is that something that, you know, as we expect maybe as judges and outside counsel say, well, that's really not your best practice. You should have those contracts. We could question that.
Well,
But-
this Hulu thing, I don't live around here. I'm way up north, so I didn't follow this,
Mhm.
you know, Hulu stuff and all that. But you know, on the one hand, you're saying how crucial it is not to divulge these threats,
Mhm.
but you have a documentary film company in there without any contract filming the whole thing. What if they captured the threats? One prosecutor's talking to another, hey, Joe Smith just said he's gonna blow up, Miss McDonald's, house.
I
I mean,
believe,
there's nothing that would prohibit them from airing that.
I believe that it was detailed in the document they received that there was an understanding that they would approve the content before it was submitted.
So that's a contract.
Is that produced?
That was produced, the Hulu
Right, I
documents. in there.
understand, but this other, I mean, how do you hire a PR firm without a contract? Do you, how do you know what to pay them?
Right.
What's their hourly rate? I mean, this just doesn't add up. It doesn't look, it's not your fault, don't get me wrong. You know, we were both in your position. We know what happens when a client serves you a big plate of you know what, and you gotta go, you turn it into, you know, beef bourguignon. And it's a uphill task here in regard to some of this stuff. I do want to ask though, why, do you know why this Williams, why the chief assistant was the one who responded and not the Oakland County FOIA director?
Sure. Sure. In the office, while there is a FOIA coordinator, David Williams is the chief assistant prosecutor. He handles all administrative tasks. In terms of dealing with the security issues and the issues that were related to this FOIA, the PR companies, he was the one that was coordinating that. He was best served to deal with these FOIAs. I mean, I should mention, Mr. Farida was the opposition to Ms. McDonald in the last election. He has served dozens and dozens and dozens of FOIA requests against Ms. McDonald. He's grieved her twice. He's grieved me. He's asked for a criminal bench warrant against me and the Oakland County prosecutor in trial court. He's asked for sanctions at every motion. I mean, it's a very sensitive situation when Mr. Farida's involved. And so the important people need to review this and make sure it's taken care of. There is no incentive not to give him the documents. There's no incentive. So to the extent a contract exists, they produced it. If it didn't exist, they said they didn't produce it. And it would be silly because, again, he's got he could go FOIA the county because the county pays those out through the purchasing department.
Sure.
So there's no there. Is it disorganized? Was it optimal? No, but that's the facts that we were given. That's the facts of the circumstances. Hindsight's always 20/20 when you do stuff. And certainly if I was their lawyer, I would advise them to get a signed contract in those situations or shore up the contract. It just didn't happen.
Well, I'm very sympathetic to your, as I explained to brother counsel, to your client's argument about these threats, but it just seems to me that there was insufficient evidence in the affidavits submitted by this chief assistant prosecutor that could possibly lead the court to conclude the manner in which it did. Now, explain to me why such an assumption, if you will, or point of view on my part is wrong.
Well, again, the court under the 6 rules analysis can look at the particularized justification and determine whether it's appropriate. And if this court as its court of appeals looks at it to see if there was clear error in that determination, and so clear error is a high standard, but the fact of the matter is the court went through the analysis, reviewed the affidavits, reviewed the facts and circumstance, and accepted the justified particularization as correct. And it wasn't just because these are investigative materials, as pointed out in the affidavit, these are part of investigations, but also that these are taken into consideration and as part of the security measures. So those are important statements, Your Honor. I mean, it's not like this is some department off in left field. This is the Oakland County Prosecutor's Office that and these were threats against the chief, the Macomb County Prosecutor. So,
Do you feel that the court sufficiently went through all of these threats? Did the court make a finding as to each and every threat, or did it, as brother counsel suggests, just lump these threats all together and say none of them are discoverable under FOIA for this particular or these particular reasons?
in this, and as we argued here, it's really not the court's position to determine the credibility of the threats. And the court is in a position where it really has to weigh the public body's interest in protecting these records from disclosure and whether it outweighs the public's interest in the release of these records. And the court did so. It weighed that and said that it really, the public body's interest in protecting these records outweighs it, and that it wasn't clearly erroneous. And we believe this decision was.
What is the public body's interest in non-disclosure? As it pertains to this case.
I think the court pointed out this very correctly. Judges, prosecutors, police officers, they are subject to threats on a constant basis. And so if the information is disclosed in terms of who they are, the details of the threat, the copycat syndrome, all those things, it's best to keep those within their investigation, and disclosing those to the public is not in the best interest. When those threats are made, security details are put into place. And who's at risk? The prosecutor, her family, the staff at the Oakland County Prosecutor's Office, those people, those security detail that are protecting her. And so we believe that it's the public body's best interest not to disclose that information.
Not hearing the because. Is it a blanket sort of exemption? And I don't mean to mischaracterize, but I'm trying to understand the gist of the argument here. Is it a blanket characterization that all of these threats have one particular commonality, and that is they were all investigated, and secondly, that they all pose a threat to which there has been a response that the public has no real need to know about because it could endanger the lives of elected officials and others?
I would restate it, Your Honor, but that's exactly why.
ahead.
That's exactly why, Your Honor.
Okay.
Or that redactions wouldn't.
It wouldn't save it, Your Honor, because this is part of our records as the Oakland County Prosecutor's Office. So he thinks we can cut out these threats from the investigative materials, and it's really not that easy.
What about an investigation, counsel, that has concluded? Would that be discoverable under FOIA?
Well, again, it's based on the information at the time of the request.
I understand.
So if that investigation was concluded later, I would also say that the security measures are ongoing, so we still believe it would not.
So the same premise holds,
Yes.
regardless of time.
Because hypothetically, let's say someone wasn't charged, but it's there's still security measures that are in place, and a concern and a watchful eye going on.
Thank you. Go ahead.
One last point, and I don't know how much time I have left.
Well,
As to the discovery issue, Your Honor, the discovery issue, there was a scheduling order from the Oakland County Prosecutor's Office that allowed discovery. Plaintiff did not file any initial disclosures, and the rule says you can't initiate discovery until you file initial disclosures. He never filed them. When Judge Viviano received in her first status conference, she said, "Look, this is a de novo review, guys. I mean, isn't this a briefing issue?" Counsel agreed to terminate the previous scheduling order, move forward in a motion for summary where he said there's no genuine issues of material fact, and the court ruled and dismissed his case. So, the fact is in the matter, he had ample time to file initial disclosures, send discovery, he didn't. And then when he had the opportunity to address the court, he waived it. So now he's saying, well, I should have had discovery before it was dismissed. The court ruled on the information in front of him, and we believe that was a proper determination.
Well, I want to give you some time to address the sanctions issue. Tell us what your client's position was relative to why sanctions should not apply here.
Well, in that very ruling, Your Honor, we raised meritorious defenses, and we made our own motion for summary disposition, and we're successful on those arguments. So those arguments had merit. There were affidavits filed. The court agreed with them. So typically sanctions are issued when there's a prevailing party. The appellant didn't prevail. So, and the court made substantive decisions on that. And as I said previous, Your Honor, he's attacking the fact that the court said it wasn't right. But again, the court went through a substantive analysis otherwise dismissed the claims based on substantive issues, not the ripeness issues, and weighed the sanctions argument and said, this is not a matter for sanctions substantively. She said both parties made, their arguments. We reviewed the facts and law. It's not a frivolous pleading, and their sanctions shouldn't apply.
Tell me why I would be inaccurate if I were to say that it is my opinion that the position of your client was that she could continue to indefinitely avoid responsibility to respond to FOIA by simply requesting additional 10-day extension notices. Was that her argument?
No, because the statute says you get 1 10-day extension. The statute talks about whether the delay was willful or intentional at that point. And it's not uncommon, Your Honor, where the 10-day extension is not enough to produce documents. I represent multiple municipalities. And many times you can continue to work through it with the requester because it just takes time. And the problem with some of these document requests is they couldn't be located. And we worked diligently in good faith. They were produced without a court order. They were produced within a couple of weeks after the lawsuit was filed. And the court said, look, I didn't have to order you to compel them. They were substantively responded to. Documents were produced, and therefore she felt it was not willful or intentional. And that's what the Arabo case talks about, is the only way that sanctions would apply is if the delay was willful and intentional.
Any questions, Judge O'Brien?
No, I think you've covered everything. Thank you.
No.
Anything further, counsel?
No, I just would like to thank all of you for your time. Thank you.
Thank you. You have 1 minute.
I don't have time to respond to the political or personal comment. What I'd say is that the willfulness is an alternative to the 250 words. It is not the only consideration for a final determination of denial. As the court stated, the affidavit itself was extremely anemic. Most of the things raised were in oral arguments or written arguments, which is not evidence. And as counsel stated, they normally will work with the opposing party. No one, or the requesting party, no one responded to a single one of her emails. At the end of the day, again, all they claimed is that their security detail, a generic security detail that would apply to every type of threat, no matter what the nature of the threat was, would not be revealed by that threat. I want to just end on that point. There has to be an explanation or causation. Merely saying we did something with security would not be revealed. A threat could say, I'm going to get you. As Your Honor said, I'm going to burn your house down. I'm going to do whatever. If the threat itself doesn't reveal the nature of the security that's been implemented.
All right, I'm gonna call it that. You've gone over your time. Thank you
Your Honor.
very much. Court will take a brief recess. Our court for the delay in the first matter, but hopefully all of our issues have been taken care of and we'll proceed accordingly. I see a lot of familiar faces, so I'm going to dispense with telling you not to read your brief. Although, as we found out from the last case, when a lawyer tells us he's not going to read his brief, that's precisely when they read their brief. So that being the case, let's move it along. Item number 2, case number 370-604, People v. Taylor. Both sides are endorsed for oral argument. Morning, counselors.
Good morning, Your Honor. I'm Kimberly Stout on behalf of Aaron Taylor, the appellant.
I will take your word for
Well,
that.
thank you. Thank you. Good morning. to
Good
all of you.
morning. Oh, let me just say one thing. If we're looking at our computers, it's not because we're watching our stocks. As judges, we're woefully underpaid. It's because this is how we use, this is where your documents are. So when you say something, I'm looking at your documents. So I apologize. I know lawyers have told me, geez, you're always looking at your computer. Well, that's because that's where all the information is. So I apologize for interrupting. Go ahead, Ms.
Oh, you're
Stout.
right there with all the young people, Judge.
Yes, well,
Not me. I can't. I've got it like, all right. Anyways, morning. Your
Morning.
Honors, after a lot of thought and a lot of reading, and even conversations with prosecuting attorney who's here today, who I've known for years, I am going to just rely on my brief.
All right.
Unless the court has questions for me.
I don't have any myself.
No, you did an excellent job for your client,
I
as
appreciate you
usual.
saying so.
Well, and I mean it. I
Thank
really
you.
do.
Thank you very much.
This was not an easy case to hand again, you're dealt a certain hand and, you know, you have to do with what you get.
To get into the particulars would probably create more issues and problems, so I think that it's best to leave it. It's interesting, and thank you very much for your attention.
Thank you.
Good morning, Your Honors. Jeffrey Kalen appearing on behalf of the people. Like counsel, I think the facts in the case law speaks for itself. I also wanted to compliment counsel because I like being back in the Court of Appeals because the briefs are just so well written, and this is a good example. I have nothing to add.
Some briefs are very
Fair
well
enough. The
written.
ones I've encountered recently have been very well written. With that, I would rest unless the court has any questions.
Any questions, Judge Kelly, Judge Ackerman? Thank you both. The matter was very well briefed. People don't understand this, but we spend a lot of time with the briefs. And if you put it in the brief, we get it. And and unfortunately in law school, they teach you oral argument is king. Not so in the appellate courts. It's the brief. And both of you did an outstanding job. So we're very appreciative. Thank you. You too. Item number 3, case number 374-749, People v. Green. Mr. Strauss, I think, is he on Zoom? Yes.
Judges, Mr. Strauss was here this morning, but unfortunately he emailed me and he had to leave for a medical appointment. And so
Okay.
he's going to waive this morning.
All right. Thank you, Mr. Wolcott. Who, by the way, in honesty, does an outstanding job. Although I hope he didn't hear that, but thank you. That matter will be submitted on the briefs. That brings us to item number 4, case number 373-729, People v. Anderson. Again, both sides are endorsed for oral argument. Good morning, counsel.
Morning, judges. My name is Robert Tomac. I represent the appellant Gregory Cornell Anderson. I will address the search and seizure issue. There is, according to my reading of the case law, 2 types of protective search. There is the situation where the immediate area of an arrestee is searched, and that's reasonably. For example, something nearby, like a closet, or something nearby, something in the vicinity. And the second type of protective search would be something more expansive, where there might be a person who poses a danger inside of a dwelling. And we submit that in this case, neither of those situations arose, and that up to that, before I talk about consent, up to that point, we submit that the search was unreasonable. Now, when you talk about consent, our position here is that we would rely on the case of People versus Dagwan, which has language that says if the search is otherwise unreasonable, then the consent has to be unequivocal, specific, and freely and intelligently given. In this case, the officer testified that the resident of the house gave her consent. So such as it is, that's our argument, that those 2 exceptions to the protective search did not arise here, and that consent in this situation was not specific enough. Otherwise, I rely on my brief.
Doesn't the fact that the consent wasn't specific actually harm your client's position in that matter, in that it was more of a general consent?
Well, I don't know what she said. It was the officer who stated it, and she said he said she gave her consent, and that was there was no other testimony about that. She didn't bring it up, or she wasn't asked about that. person who allegedly gave the consent testified, and she was not questioned about it. So there's very little evidence about its specificity, or whether she intended to actually do that, and whether she intended to actually give the officer consent to go through her house, go upstairs, go into the bedrooms when everybody was already outside. And she also said that there was no one inside.
Let me ask a question, if I might, counsel. If a police officer knocks on my door and says, "Can I come in and search your house?" and I say yes, would you not believe that, or would a court not hold that that was an unlimited search, that unless I restricted the search in some way, that a police officer would be free to go through my entire home and search even within boxes or drawers or things of that matter? If they're my point being, in the absence of any limiting language, isn't the consent general and allows an officer to essentially look at anything?
Well, then what does this language mean from Dagwan, People versus Dagwan? There are situations where whether or not consent was actually given, whether that the person who was gave the consent actually was maybe just intimidated and didn't realize what they were doing, or what simply wanted to be agreeable, not realizing the consequences of giving the consent. So there has to be situations.
Well, now you're talking about voluntariness. What I'm talking about is scope.
Scope.
What I'm suggesting is, in the absence of any limiting language, if someone tells a police officer, as I think is what happened here, when asked, "Can I search your home?" and they say yes, that in the absence of any limiting language, that gives the officers full bore to go through whatever they want to go through.
Yes, unfortunately, that's how it would be interpreted, but someone saying yes, do they really mean, yeah, sure, you can go upstairs, you can go into my jewelry box, you can go in the closet, you can look all through, you can pull out all the drawers? Do they really mean that when an officer asks them, can I come in or can I search? And they say, yeah. So I understand that the scenario you present, yes, technically that would be interpreted as a expansive search.
But you're saying here, because this woman, I think she was detained or something, that because of the detention, that her consent was not voluntarily given. Is that one of your points that you're making to us?
Well, all right, so I guess I'm not making the distinction between it being unequivocal, specific, and freely intelligently given, and whether or not it's voluntary. I would think that they go hand in hand. It could very well not be voluntary if it wasn't specific and intelligently given. So I submit there's a distinction there, Judge. But
All right, understood. Thank you. Any questions of counsel? I do not. Thank you, sir. Subject, or plenty of time for rebuttal. Good morning.
Good morning, Your Honors. Mitch Tibbs on behalf of the people. I would just rest on my brief and answer any questions that the court has.
So let me get this straight. Wayne County actually knows how to get to the Court of Appeals?
But you made the same joke the last time
I
I was here
know,
before.
and I'm
you.
gonna always make the joke. It's rare we get to see you guys.
I do my
It's-
best, Judge.
It's just a wonderful, wonderful outing, isn't it? When Wayne County says, "Wow, we're actually going to participate in an appellate argument." But in all candor, you did a nice job on the brief. Let me ask you, if you don't mind, counsel, since I have you here. Brother counsel seems to be, at least for me, setting forth a rather novel argument where he's tying the voluntariness of consent to the scope of consent. What would be your rebuttal to that argument?
I'm unaware of any kind of case law support for that. Obviously, those are two separate questions, right? Whether or not a consent is voluntary does not necessarily impact the scope of it, right? Just because you voluntarily consent does not stop you from limiting the consent in any way. And there's no evidence that that happened here. So, I mean, could there be a situation where maybe they're tied together? Maybe, but I don't think that's here. And I think it makes more sense to do those inquiries separately, right? What was the scope of the consent and did you consent voluntarily?
Do you recall, and if you don't, I don't mean to, jump on you, but, was the person who gave consent, was she being detained at I can't recall specifically.
I was trying to pull the transcript up to see if there was any clarity on that. Obviously, this wasn't an issue at trial, so it wasn't really,
Right.
my recollection was that it wasn't brought out.
Okay.
And I don't recall specifically the sequence of events, right? The officer knocked on the door after seeing the car, ordered the occupants out, and then asked for consent. But I don't know that the sequence was ever specifically laid out because this was not an issue at trial, right? It was out of the house. Can we search? Yes. Went in and found the gun.
I appreciate that. Thank you. Anything further? Any questions I mean, we have them here. We might as well take advantage of it. Thank you again. It's nice to see you.
You too, Judge. Thank you.
Any rebuttal, sir? I appreciate it. Thank you both very much. The matter is submitted. Item number 5, case number 371641. Boy, I'm gonna say her first name, Marlena versus Total Construction and Renovation. And then I'll have counsel tell me how to pronounce their client's last name, because I'm not even gonna take a stab at it. Franzak, what's the, Duchinsky, thank you, sir. Good morning.
Morning. Morning, Your Honors. May it please the court, Robert Kerr appearing on behalf of the appellants. I'm here with my co-counsel, James Bashai. For the record, James Bashai.
Good morning. Go ahead, sir, when you're ready.
This case, Your Honor, is about essentially a construction contract that was entered into between Total Construction and Mr. and Mrs. Franzak. Not a party to that contract was Jason Saborski or the Marlene Franzak 401k Trust, which is a separate entity, separate EIN number, organized as a separate consideration for the benefit necessarily of the beneficiaries, subject to certain rules and regulations. In this particular matter, there was a jury trial that was initially conducted in July of 2022. That jury trial resulted in a mistrial being declared by Judge Gaddy. It was declared by Judge Gaddy because we objected necessarily to the fact that there was a consideration of the unification of the 401k trust with the actual individuals. We indicated that that's impermissible. They're separate entities. And as a question of standing, real party and interest, that the 401k trust was not a party to this litigation. All of the payments that were made by the Franzaks were done by the 401k trust. They had no, and they admitted they had no payments at all that were made individually by them. But yet they were saying they were out of pocket.
You didn't bring this up until the trial.
I apologize, Your Honor.
You didn't bring this up until the trial.
The answer to that is actually no. That was brought up in pretrial matters before the court because we had an issue associated with discovery, because we had requested check registers, we had requested all the checks, we had requested all the bank statements, and we got only 3 documents, and those were the 401k trust checks that had been cashed. We didn't get the rest of it. That was actually brought up. It was not necessarily brought up. And I'm going to diverge a little bit to talk a little bit about the question that you brought up. Judge Gaddy had indicated in front of the jury that the personal funds of the 401k funds were personal funds. There's no distinction. We said that's not true. That's wrong. And as a consequence, we asked for a mistrial. Judge Gaddy granted the mistrial. Then Judge Gaddy said, prove it. Let's see if through a motion for summary disposition what this argument is really all about. And at the same time, she said to the opposition counsel, Mr. Strenger, you can file a motion for sanctions and costs too. Now, the jury's gone. The mistrial is declared. They rescheduled the trial about 2 days after the mistrial was declared. Ultimately, that was done in front of a different judge. Ultimately, we prevailed in front of a jury who issued a judgment of no cause for action on all of the counts. Judge Gaddy denied our motion, recognizing that it's the same argument that was made at the time when she was opining that the funds of the 401k trust were personal funds. The issue of the $14,000 and some odd change sanction was rendered directly as a consequence of the mistrial. But we didn't cause the mistrial. We raised an issue about standing, which can be raised at any given point in time in the proceedings. The judge granted the mistrial without reprimanding anybody, recognizing the fact that she had misspoke.
Counsel, you're kind of misrepresenting the record. What happened here is, and to Judge Kelly's question, which I never really did hear an answer from, you essentially contended that there was some criminality or potential criminality involved in this person taking money out of her 401k to pay to pay your client. And you kind of caught everybody off guard, including the judge. And so you made an argument which caused the judge said, I don't know, this is the first I've heard of it, declared a mistrial based on that, and then said, prove to me you made a legitimate argument, let me finish, and then held you did not. And that's why it doesn't matter what happened in the subsequent trial. Your actions caused a mistrial, and it turned out not for a good reason.
That's actually not true, Your Honor. And with all due respect, what happened was she declared the mistrial. Then they got into the issue.
That's
It wasn't vice versa.
You raised an issue which caused the court to stop and say, what are we doing here? And the issue was, in your opinion, dispositive. When it turned out not to be dispositive, that's when the court sanctioned you.
But why isn't it dispositive? Let's deal with that issue. The simple fact is that there are rules associated with the 401k trust. There is criminal behavior associated with the 401k trust. There is fraudulent behavior. There's limitations associated with that. We brought to the attention.
That had nothing, none of those issues had anything whatsoever to do with anything that was at issue in this case. If there were violations of the IRS code, that had nothing whatsoever to do with this individual's ability to bring or not bring a lawsuit. And that's what the court ultimately ruled.
The issue here is one necessarily of the fact that they're asking for a windfall. They're asking for a windfall for monies that they didn't have, they were not damaged for. No money came out of their pocket. The proper party in interest, 401k trust, was not a party to this litigation.
Well, that goes back to my question, which was, if
Yes,
you
sir.
receive checks written from a 401k trust, you knew that it was from a 401k trust. Why wasn't a summary disposition motion or something brought up so that you could have avoided the trial by saying, you know, we're sued by the wrong party? And wasn't that part of what the judge was?
Well, the issue isn't why wasn't it done before? And again, why weren't we given all of the materials which we were promised to be given?
Well, how many did you
The-
have? You said
the-
you had 3 or 4 checks written from the trust, right?
It's my understanding that the Michigan Board of Appeals to the Supreme Court has
Hang on,
always said
counsel,
that.
hang on.
Yes, sir.
I need you to answer questions when they're asked. Judge Kelly asked a very direct question. I would very much like to hear the answer to it. Could you please answer it?
Sure. The only
Wanna
thing
ask it
that,
again,
Did
the
you
only
have- Did you
thing,
have 3 or 4 checks? I thought I heard you say, and I thought I
A little.
read, before the lawsuit was commenced, as the place was being, you know, rebuilt or restored.
what I can tell you is that
I mean, did you or not? I mean,
there was no summary disposition motion
I'm asking if you
predicated
received
upon.
checks before the lawsuit was filed from the 401k trust. Is it
Okay,
a yes or
but
no?
I don't want to cause any disrespect. I want to answer you directly, but I'm just.
Well, it'd be
would
the
like to
first time,
hear-
wouldn't it? So,
Sorry, sir.
it'd be the first time you're answering directly. Did you or did you not get 3 or 4 checks from the 401k trust? That's not a difficult question. I hope it's clear enough.
Did,
Come on, gentlemen, this is not a
The-
difficult, let me finish. If you don't answer these questions, we're gonna just tell you to sit down. It's a very, very simple question. Yes or no? Did you have, let me finish. Did you have in your possession these checks prior to trial? Yes, no.
The answer is yes, but I also need to tell you, I apologize. I don't have my hearing aid today. And so when I'm consulting him, I ask him, what did you say? I don't mean any disrespect. I'm trying to answer your question directly and forthrightly.
Then tell us you didn't hear the question. Don't play games with me.
I was
And
not
that's
playing
exactly
games.
what
I
you're
said
doing.
exactly that. I couldn't hear.
No, you didn't say that, but
Okay.
anything else? Judge Kelly?
No.
Go ahead.
For purposes necessarily of the record, the fact that the Perskini principle of law has been upheld by this court on numerous occasions, including the Narion case, including the Denmark, Fenton County House case, Carmack, and People versus Schimmel. In the Narion case, this honorable court indicated that the imposition of sanctions at the time of issuing a mistrial was premature. You have to wait to the ultimate disposition of the proceeding. And this is what happens in this case now. Because at the time of the issuance of the mistrial, Judge Gaddy indicated you can file a motion for sanctions. That was that same day. The fact that she granted that on that same day was premature. What she has effectively done was destroyed the principle of law set forth by Perskini and all of its progeny, which says you cannot do that. It's an absolute. It cannot happen here. So there was no egregious conduct. There was nothing but for the fact of simply saying that the person in interest here is not the right person in interest. And when we say that somehow we're to blame for that, that's putting, I believe, form over substance, because you have a party that's not entitled to be in court to seek those damages, that are seeking damages that they were not out of pocket.
Well,
Apologize for my
point-
hearing loss. If there's any questions, I'd be
well,
happy to
I
answer
guess
anything.
My point was that.
May I approach a little bit? Just so
Sure,
I can
and
hear
I'll
you.
speak up a little bit, and I apologize if you didn't hear me. Okay, the point I was trying to make is that if you had those checks beforehand and a summary disposition motion was filed addressing that very issue, you know, the court wouldn't have had to waste all the judicial resources of assembling a jury and going through all of that before you raise this.
We didn't have all the checks. We didn't know what other checks that may have used to pay
Okay.
for construction. We were waiting for all those checks.
And they came out at the
They
trial
had the
then?
Register, we had
Yeah.
the bank statements, we had absolutely.
What's the answer to his, what's the answer to his question? Did you have all the checks, yes or no, prior to trial?
The answer is.
Your co-counsel has the answer.
There's the answers.
Yeah. Is it okay if he answers that?
You gotta speak into the mic, please.
The concern was, is that I'm understanding, why wasn't it filed or summary disposition filed prior to trial? A lot of discovery between.
Let's back up a second. Let's answer Judge Kelly's question.
That's the one I want to answer.
The question was, again, very simply, did you have the checks prior to trial? Yes, no.
Yes, but not all, and not all the financial.
So the
documents we asked
answer is no. You did not have all the
No,
checks.
That's
all.
correct.
That's
We had
correct.
3 checks.
Okay.
That's it.
Now, one of you has to speak at a time, not two, please. So figure out who it's
I'll
gonna
finish one.
be.
3 out of how many checks?
Oh, multiple. I think we received a total of maybe 6 to 8 checks out of multiple checks that may have been written. Whether they were personal ones that were written, we had none of those. The only ones we received after the last discoverable deposition, that deposition was even conducted after the summary disposition deadlines. And I think that may answer your question, why couldn't be filed? Because the original court scheduling order wouldn't allow it at that. At that time, we raised it at the trial, and that's where the summary disposition was allowed to be filed by the judge afterwards, after the mistrial was declared. I hope that answers your question.
It does. Thank you very much.
Anything further?
Any other questions, Your Honor? Thank you.
I don't have
Thank you.
any. Do you?
Thank you.
No.
Any questions for opposing counsel?
No.
You want to put your appearance on the record, sir?
Good morning, Your Honors. Richard Strayer on behalf of the plaintiffs and the appellees, Marlena Franczyk-Buzinska and Randall Fritchie.
Thank you, sir. The matter is submitted.
Thank you.
Thank you.
Thank you.
Case number 374773, item number 6, Barber versus Lawrence Mora, MD. Both parties endorsed. Sir, we've got some issues to take up with you before you start your arguments. First of all, you sent to us, you sent to sister council nonsense cases, and that's completely unacceptable.
Absolutely, Judge.
Not only did you do it in our court, you did it in the court below. And this is a case where you're asking us to believe that you heard something from jurors that no one else heard, but yet I have numerous, and I know my colleagues documented it, numerous examples where the cases that you cite do not stand for the proposition for which you cited them. Now, this is something that this court takes very seriously. This is a huge ethical lapse.
Thank you, Judge.
What's your response?
Thank you, Judge. I did file a notice of correction, a brief identifying the citation.
Months after you wrote the stuff.
Yes, sir, Judge. And the errors do not affect the substance of the legal arguments which.
do. And
Thank you.
you filed a reply brief after sister counsel pointed it out that the quotes didn't exist and you
Yes, sir.
still didn't respond to it. Why did you wait until a notice of correction 6 months later, 8 months later?
I apologize, Judge. I don't have a specific answer in that regard. I thought I did act timely. But I did in fact,
use artificial intelligence for the notice of correction?
Absolutely, Judge, and I do apologize in that regard. It was at early stages of, um,
Okay, so you did at the trial court. It was pointed out that some of the cases didn't exist. You did in your brief here. Did you again use artificial intelligence for the notice of correction that you filed more recently?
yes, I did, Judge.
What programs did you use?
I believe I used Claude 4.7 and ChatGPT the 5.49. Also had Westlaw and Lexis.
Use Westlaw or Lexis to check the cases in the notice of correction?
Judge, I do believe that I did. Honestly,
I see a case, People v. Miller, for example, on page 2 of your notice of correction has a quote, extraneous prejudicial information is improperly brought to the jury's attention. I looked at that case, it's not there. That quote doesn't exist in that case again, in your notice of correction.
Yeah,
Cases that don't exist.
Judge, I do sincerely apologize to the court and sister counsel. It was my intent to not, of course, file anything of such kind before the court. And that's why I filed the notice of correction.
But you did it numerous times. I mean,
I understand, Judge.
this just cannot be tolerated. And I appreciate that you're apologizing, but sister counsel had to bill her client for work that she had to do because you made stuff up.
And Judge, I do appreciate that, and I do recognize that, Your Honor, and I did in fact attempt.
But even
in
when
good
you
faith.
tried to make it better, you made it worse. You continued to rely on the exact same AI that got you here in the first place. And again, you did it in the court below. You did it here on numerous occasions.
And Judge,
We're probably gonna have to do something about this.
and Judge, I do appreciate and understand that. It would never be in my intent to file in front of any court, let alone this court, Judge, in that regard.
This AI business, I'm one of the least knowledgeable people about it, okay? So I don't touch it because I don't understand it and all that, but I don't know how long you've been in practice, probably a while. You came up at a time when that didn't exist, and maybe it's just time to go back to until they really improve this stuff, because this has happened and it's not a good look.
It does.
You mentioned Westlaw and Lexa, just stick with those or something.
An extensive cost, Judge, and so I do apologize to the panel for the additional work as well as my sister counsel, Your Honor. But the errors do not affect the substance of the legal arguments with respect to Budson and Reamer, the primary cases in this, that support our arguments. And also the court's own December 2025 decision in Bergarva. The core legal framework is sound and has been verified, and I will take full responsibility for the errors. And I do apologize to the court and sister counsel. If it may please this most honorable court, again, it's Ronnie Cromer on behalf of the appellant plaintiff, Ms. Joyce Barber. And I would like to reserve at least 5 minutes for rebuttal, Judge. And this case is about whether a trial court must hold an evidentiary hearing when 2 sworn officers of the court, plaintiff's counsel and co-counsel, filed declarations under penalty of perjury describing specific jury misconduct they personally witnessed in the jury room. The misconduct was specific and concrete. One juror admitted he researched a medical measurement on the internet during trial. Another juror admitted he discussed the case with his mother, who had undergone the very same hip surgery at issue, and asked about reviewing her x-rays. Both of these acts violate juror oath under MCR 2.511 and constitute extraneous information under MRE 606B1. Now, when counsel raised the issues at the motion for mistrial, the trial court responded, and the transcript reflects, I believe, at page 42. It says, "I don't remember that at all." The statement, Your Honors, is precisely why an evidentiary hearing is required. Now, when the trial judge herself has an incomplete recollection of what happened, the 2 attorneys, both in good standing with the bar, both practicing over 25 years, swore under the penalty of perjury, and recognizing that under MRPC 3.2, our duty of candor to the court, that specific misconduct occurred. The factual dispute cannot be resolved without a hearing. Now, Budson requires it. REMA requires it. This
The court did have a hearing,
Thank you, Judge.
and the court decided that what you claim was said wasn't said. It's
Well,
that simple.
and I agree, Judge, and it goes
So
back to.
why would we have another hearing? What would be the intent? What would be the purpose?
Well, Judge, I think that's the issue here. I think that because there wasn't a hearing and it's just the competing attorneys, of course, they're going to say one thing and we're going to say one thing, but two attorneys in good standing.
Well, not
Actually-
necessarily. I mean, what you're advocating here is that first you indicated that they lied because you said, well, they said so under claim of, and this wasn't what happened. So you're contending they lied. The court ruled otherwise. The court said, I don't believe you.
Well, Judge, and I think that's where the requirement for the evidentiary hearing is. Once you make a colorful,
But the court's gonna do that hearing, right? The court ultimately is gonna make a decision as to whether these comments were made, and it already made that decision.
well, I think, Judge, what we were specifically asking for is that based on the case law that we provided, Hudson and Reamer, and even since post filing, the court has made a decision in the Bergarva case, decided in December 22nd of this past year. That was
What case? Give me the site on
Sure,
that.
Judge. It's Court of Appeals number 367.
Is it published?
It's unpublished case, sure.
All right. Did you provide a copy to sister counsel?
No, I didn't, Judge.
That's in our rules.
Again, with respect to the fact that it was decided in December this past year, the court held, excuse me, it was a criminal sexual conduct case. And in that case, the juror number 13 conducted independent internet research. Specifically, she researched the Larry Nassar timeline on her own. When this came to light, the trial court held a full Reamer evidentiary hearing. And the court questioned the juror and other jurors developed a factual record and ultimately determined that the research did not create a real and substantial possibility of affecting the verdict because other jurors silenced the researcher and the juror testified that she would have voted guilty regardless. But what the court held there was affirmed the denial of a new trial, but critically it affirmed because the trial court followed the correct procedure, which is what we're asking this court to do here. And on page star 19, and I quote, once an individual establishes a colorable claim of extraneous influence, the trial court must hold a Reamer hearing to determine prejudice. And it's not discretionary, it's must. The Court of Appeals expressly confirmed that juror internet research during trial constitutes extraneous influence requiring a Reamer hearing. So that first, it confirms that the juror internet research is extraneous under MRE 606B1. And the defense argues that the 25 millimeter conversion was cumulative. But Bergara says it doesn't matter. The act itself the act of independent research itself is extraneous conduct. Second, the Court of Appeals affirmed Bergara's specifically because the trial court actually held the hearing. We requested the hearing at the mistrial motion, and in the alternative, we asked for an evidentiary, and the court denied it. The trial court here refused to hold any hearing. If the trial court does what Budson requires, the Court of Appeals affirms. And if it doesn't, it can't survive appellate review. Third, the trial court in Bergara was able to determine prejudice, not only because it developed the record through testimony. Now, the lower court judge has no such record. She denied the hearing and made a ruling on competing attorney representations alone. Now, defense might attempt to distinguish Bergara and say that, see, even when there is internet research, the trial court denied a new trial. But again, Your Honor, Bergara was only possible because the trial court held the hearing. The Court of Appeals affirmed because there was developed record showing research didn't affect the verdict, there is no such record here. Without a hearing, there's nothing for this court to review and nothing for the defense to point to as evidence of harmlessness. So in Bagarva, since it was decided by this court on December 25, and after briefing closed, in Bagarva, a jury I'm sorry.
Cite again for Bagarva?
Thank you, Judge. It's Court of Appeals number 363. I'm sorry. Oh, 367, 369, December 22nd, 2025. And if I could also refer the court to United States versus Hill, decided.
You know, you're bringing up a case for the first time that's not any brief or notice of correction. I just don't know how.
Thank you, Judge. It was post filing. It was just decided in January of this year. Thank you, Judge. But in the United States versus Hill case, number 24-1801, Sixth Circuit case. And again, it was filed post brief authority. And in that case, Your Honor, in the Eastern District of Michigan, is a drug conspiracy case. And during the trial, juror number 9 disclosed to other jurors that her ex-boyfriend had overdosed on heroin and had a connection to Helen Street, the very address in the defendant's drug operation. And the district court immediately dismissed juror number 9 and conducted a Reamer hearing, questioning each remaining juror individually about what they had heard and whether it affected them. And the court held, citing both Reamer and Smith versus Phillips, 455 U.S. 209, 1982 case. And the key language there on page 15 and 16, and I quote, "A Reamer hearing is the established remedy for allegations of juror partiality, Quote, "When advised of possible juror misconduct, district courts are required to investigate and to determine whether there may have been a violation of the Sixth Amendment. District courts must determine the circumstances, the impact thereof upon the juror, and whether or not it was prejudicial. In a hearing with all interested parties permitted to participate." Now, Hill's persuasive from the Sixth Circuit and the Federal Circuit that covers Michigan. It reinforces Bagarva and Bauer pattern. When extraneous influence is alleged, the remedy is a hearing, not a summary denial, which was done in this particular case. And additionally, the large demonstrative exhibit, a poster board showing the screw protruding into the area that caused plaintiff's injuries, is sat in front of the jury box 5 days in a row, about 5 feet away from them, the entire trial.
Hang on, excuse me.
Yes, sir.
Mr. Wolcott, we're getting noises coming out of our electronic devices here.
Okay, out of your iPads there,
No, out of the
or out of the
television.
mics? Okay. All right, let me get a hold of someone.
Thank you, sir. Go ahead.
Thank you, Judge. I appreciate it. And as I was indicating, we had a large poster board sitting right in front of the jury throughout the entire trial. Every witness looked at it. Every witness was examined on it. Every witness talked about it. It was our primary exhibit. The foreperson sought additional exhibits, could not find them, and ultimately abstained from voting. The trial court acknowledged on the record that it was her responsibility to send all exhibits back to the jury, and she failed in that regard. We asked the court to remand for an evidentiary hearing that Budson and Reamer would so require, or an alternative, reverse and grant a new trial. Now,
Anything further? Asking for a remand. Any questions of council? Why don't we hear from sister council and give you an opportunity to respond?
thank you, Ken.
Mr. Wolcott, can you please take care of that issue?
Working on it right now.
If
Good
it,
morning, judges. Alice Bell appearing on behalf of defendant Dr. Morawa.
I apologize. It seems like amateur day here.
It's perfectly all right. Tech is a mystery to me as well, so
It shouldn't
I'm
be.
relying on Mr. Wolcott as well. So I would just like to highlight that everything is in, my brief is very thorough, very detailed. The only point I plan to make this morning originally has already been made by Judge Ackerman about the notice of correction that was filed. That apparently, again, cites a case for a proposition which it does not stand for. Other than that, unless the panel has any questions or would like some clarification on any of the points made, I will just take your questions.
I appreciate that, counsel.
I don't think it's necessary.
There being no argument, there's no need for rebuttal. The matter will be submitted. Thank you. Item number, do you want to? Well, we're going to take a real brief break and hopefully that'll be fixed so that you lawyers don't have to contend with it. I apologize again. I apologize to the last attorneys who had to put up with that. Well, we resolved our tech problem by shutting the thing off. So my sense on behalf of my colleagues, our sincere apologies. This has not been a good day so far. So we're gonna try it again, and we'll start with item number 8, case number 374570, Walker versus Citizens United. I'm sorry, I skipped 7. I apologize. I screwed up. Thank you, Judge Ackerman. Case number 374086, Knott versus Allstate. Sorry about that.
One on the 11 o'clock.
Correct.
Okay. Daniel Steele, on behalf of the appellant, I'd like to rely on my brief and we'd be happy to answer any questions.
I don't have any.
Yeah, this is the one where the judge said, how about this? Motion denied.
You're correct, Your Honor.
Yeah.
This is one.
Well, I'm guessing you'll see her again. I know you're looking forward to it.
Right, right.
Thank you very much, counsel.
Thank you, Your Honor.
That matter is now submitted. Now I will call Walker versus Citizens United. I'm just helping you get your steps in, counsel.
I appreciate it. It's nice to be thought of. Jason Blankenship on behalf of the appellant. I know I did not get endorsed for oral argument, but I'm here. It's nice to see you all. If you have any questions, I'm happy to answer them. And
thank you very much.
I hadn't seen sister counsel in a number that won't be mentioned, so that was the other reason. So otherwise,
I have no questions.
Nothing. Good morning. Good afternoon. I apologize.
Good afternoon. I'm Christina Ginter. I represent defendant appellee Citizens United Reciprocal Exchange or CURE. And again, I will rely on the briefs, which I think have been laid out the issues clearly. If the court has any questions for me, I'd be happy to answer them.
Any questions for counsel? I thought it was very well briefed. I don't have any questions.
No, I don't.
Judge Ackerman, thank you both very much.
Thank you.
Appreciate it. The matter is submitted. That brings us to item number 9, case number 371270, Sleeman versus Sleeman. Good afternoon.
Good afternoon, judges. Ann Argeroff for appellant, Gary Sleeman. I'm going to rely on my brief. I was just going to make one brief comment. I hope it doesn't, if that's all right.
Oh, yeah, we're not, we're in a good mood. Believe it.
I'm just going to go to what I believe is the crux.
You didn't send us bogus cases. You know how to answer a question when asked directly. These are very small things we ask, I think.
I'm afraid to ever use AI, and I probably never will, so.
You know, here, and here's the thing about it, and I defer to my colleague Judge Ackerman. He is kind of our expert in this area, but there's nothing wrong or inherently evil about AI. We've all used AI, Microsoft Word and spell check and that. But ultimately, and you know, everybody's talking about we need new rules. We don't need new rules. When you give me a case and it doesn't exist, there's a rule that already is in place that deals with that. And when you sign it, as you know, and again, I'm just shooting my mouth off here. You're telling us that, and you know, candidly, we're not very smart. That's why we're judges, right? And so we need to rely on you folks to tell us, you know, this is why you should, this is how you should rule, and this is why you should rule. So we do depend very extensively on this, on the papers that you present to us. And when you present to us a bunch of nonsense, it makes our job a little more difficult. We don't like to have to work. We're public servants. But in all candor, say whatever you need to say, counsel. I think what we have here, oddly, with a person who a judge who used to be a justice of the Supreme Court, is there's not much of a record here for us to review. We don't know why things were awarded the way they were. With regard to your contention about the son, I take your point is taken. I don't know if that helps your client. But as to the other points about, you know, why did the court make this ruling? Was it an equitable ruling? We don't know. I don't think we have enough information.
And I've had other cases like that where the trial court wasn't clear on why it was equitable, and those cases had been remanded, if that's what we're talking about.
I only speak, you know, I haven't
Right.
discussed it with my
Sure.
colleagues, but
Of course.
that's kind of where I'm at. I'm sure you don't have an objection to that.
No. And just very, very briefly, as to the issue of the third person interest, the cases relied on appellee. They mentioned in their appellee's brief that Mr. Sleeman attempted to use his son's name to hide the Garrison condo. Well, the Garrison condo was given, you know, the deed was signed in the Garrison condo in 2020. The divorce wasn't filed until 2022. They followed family tradition in terms of how they treated their children and giving them property. And I think things changed when the divorce was filed. I mean, this family's been through a lot of tragedy, and I'm sure.
They lost, I believe, three children. Okay.
And
That's awful. I can't even imagine.
I know, it's terrible. In terms of the equity, our position was that she was given the entire condo. We believe that was inappropriate. The court didn't have authority to do that. And further, it gave her more assets and further skewed the property division.
Let me ask you specifically about the condo. If the son, and I suppose it's true, the son is the co-owner, so to speak, because according to I can't remember, the plaintiff, in order for him to be able to live there, the association required that he be on the deed. Is it, I want to make certain I understand your client's position on this particular matter. Is it his position that the son owns the condo outright?
His belief is yes, that his son owns the condo, just as it happened with I believe it was West Oaks, or the previous property that they had given their son, which they gave to him, he owned. They paid the mortgage on that, but it was his property. I believe he sold that and used that to purchase. I have to look back through my statement of facts because I was looking through it and now for some reason it's just gone out of my head.
That's all right.
But he used that to purchase his pharmacy that the family had given their children property. And that was in the tradition of the family. That's what they did with this. I think in this case, there's testimony. I think that if there's going to be a dispute over title, it should be dealt with in a court that has expressed jurisdiction over title claims. But I think here, the son, I think, was under the impression that it was going to be his property, though he understood that was certainly one of the reasons that he was put on the title in 2020, 2 years before the divorce was filed. But also, this was the party's tradition. This is the family, the way the family acted in terms of giving their children property. And he did pay back some money on the previous property that was given to him, but he did that voluntarily and, at his father's request. That was voluntary.
Did the plaintiff continue to live, or does the plaintiff, if you know, continue to live in the condo that has the son's name on it as well?
Son still lives there.
Just the son?
Well, his family, his wife
Okay.
and their daughter now, I
But
believe.
not the plaintiff?
No, the plaintiff never lived there. I think in their statement of facts, we mentioned that the parties were thinking, oh, we're going to live here when we retire. They decided not to. And then then the quit-killing deed was put in Michael's name and the plaintiff's name in 2020, again, 2 years before the plaintiff filed for divorce. And that was similar to what had happened previously with I believe it's West Oaks property or the West Village, excuse me, the West Village property.
So the plaintiff still has a legal interest in the
Yes.
condominium?
Yes.
Okay. Now,
I believe that quitclaim deed, the 2020 quitclaim deed is still in existence.
okay. Now, the property in Lebanon, the plaintiff owns that outright now?
Yes, and that's
Okay.
one of the issues that we raised I don't think any of us know the status of that property right now.
Yes.
But
I would assume it's not good.
I'm not sure if it was in northern Lebanon, southern Lebanon, around Beirut. It's in southern. We don't know.
All right. Anything further?
No.
Any questions of counsel? Ample time for a rebuttal. Thank you. Good afternoon, sir. So before you begin, just to clarify this in my mind, your client continues to have a legal interest in the condominium, correct?
Absolutely.
And she does, not that it matters, but just out of curiosity, she doesn't live there. She just maintains a legal interest, correct? As far as you know.
She doesn't have a choice. She can't live there.
Okay.
Her son's there, and it's hard for especially a new grandmother to kick out her son and her grandchild and his wife, and she's quite frankly not going to do that.
I got some Sicilian grandmothers that
Oh, I
would
get
have
it.
no problem whatsoever doing that at gunpoint.
Well, to answer your question, the good news is that she does rent a condo in the area,
Okay.
and the son has been paying for that.
So that was what I was interested in, obviously, is does she have a place to reside? Because clearly if she did not, that would be of utmost importance.
Yeah. So, and I think, like you indicated, I was part of the trial, but not here to testify as a witness, but I was part of that. And there was a lot of things on the record, and you are correct. The trial court's record is not as extensive as one would like to understand why the judge came up with what she came up with. But the reality is she was there. She was the trier of fact. She heard the witnesses. She heard the facts. And I could sit here and bore you with the 4 days of trial that we went through and why the judge made her decision. But it's not tradition the way things happen in this family. It's the way dad controlled the narrative and what he wanted. You know, sister counsel brings up West Village, which is important in this case because West Village was a property that first they claimed was gifted to Michael, the son. But then Michael ends up getting a loan on it. Then he ends up selling it, then uses it for a pharmacy, but still gives his mom $77,000 or $76,000 upon dad's request, which is not voluntary. That's because dad told him to do so. And I think we forget the mere fact, based on the facts that were suggested in the briefs, especially appellant's brief, is that Michael moved to the condo in October. The deed wasn't signed until December. Why? Because the association knocked on his door and said, you can't live here. That wasn't voluntary. See, I think with subject matter jurisdiction, and I may be wrong, it's kind of a new novel issue to me, is yes, fraud should exist when you bring in a third party, but the question should be, does fraud have to exist? We never had to bring in a third party here because we never alleged fraud. There wasn't allegations of fraud. The court had subject matter jurisdiction of this marital estate, of this marital property, and found through Michael's own testimony as a witness that he was willing to pay his parents back. He never paid anything for this property, and it wasn't a gift. So all these things taken in consideration by the court and by the trial judge said, hey, this is wife's property. So that's why we didn't have to bring in a third party. And I think our second argument, which I didn't hear any questions about, so maybe it's not even a concern.
Can I interject here?
Sure.
If I might. What I'm having some difficulty understanding, and not through any fault of you or sister counsel, but rather the trial court, is the trial court, as part of its divorce decree, ordered that the son pay your client for the condo. Am I correct in that assertion?
If the plaintiff wished him to pay for that, it was her choice. It was
Okay.
mother's choice on whether she wanted to have the son vacate or pay the fair market value. And throughout testimony, he said, I would pay them. That's kind of why I think the court did that. The court was giving that decision back to plaintiff, to the mother.
Well, that raises the issue that I have, and that is what authority did the court have to order him to do anything?
So I agree. The court doesn't have any authority over him, but that's the point. See, Michael's interest, you can't take somebody's interest away of property when they don't own the property. And now I understand we're form over substance. We're not, see, the court also has to be realistic, just like in Reed and just like in Cassidy. There's a reason why the trial court put those specific cases, because one of the things in that case, they were talking about the reality of what's happening. And the reality was the way this family kind of complicated property within the family. It's not that Michael owned a property or Zachary, the other sibling, owned a property. They were putting in properties in names of each other when they really had no ownership interest per se. And I agree with you, and I don't think I answered the question.
No, you answered it.
She didn't have I don't think the court had the power to force Michael, hey, pay mom or vacate, even vacate. She's not an eviction. It's not a district court with summary proceedings. She was giving the option. And why? Because Michael in his own testimony said, I'll wait for the conclusion of what the court rules. Michael was hands out. He didn't want to deal with mom or dad. He didn't want mom or dad to tell him what to do. He kept saying, I'll wait for the court to tell me what to do.
But it obviously inures to the benefit of your client in this respect. If the court, as part of its settlement, was that your client should receive whatever funds the condo was worth, and I apologize, I don't remember a number, and it doesn't matter, but and the court has no jurisdiction over him, then that's a kind of a nothing, if you will, big nothing burger, and to use a real precise legal term, relative to your client's interest in the divorce settlement, right? Or the divorce judgment, excuse me.
I agree, but the court has equitable powers, right? Has equitable powers to distribute marital estate and marital assets. I looked at Michael as a.
But if Michael doesn't, and again, it's to your client's benefit, but let's say your client says, all right, Michael, you owe me $200,000. And Michael says, no.
Right.
And she says, all right, I'm going back to court. The court has no jurisdiction over Michael, so it's an illusory.
I agree.
Yeah, I'm saying that.
Yeah, I mean,
I didn't think you just.
No, I agree. And there's, I guess there's the issue, right? How are you going to bring Michael in? There was no fraud. And now they're tenants with rights of survivorship. You can't partition. So now it's like, what is this property stuck between son and mother?
Right.
So I think.
And that's a terrible onus,
It is.
candidly, to put on your client. To say to her, as part of a divorce judgment, you can go after your kid. What I'm suggesting here is there were things that the court did that I thought, I didn't understand, that maybe the defendant has a right to go back and have the court explain it. But also, I think that's true of your client, and I think particularly with reference to this particular issue, because I assume it's a substantial amount of money. And if your client, I've never seen in my tenure on the bench a court that issues an edict that says to a child of a marriage, you will pay your mother back at the mother's suggestion. I mean, that's just not fair to any mother.
I completely understand what you're saying, but I don't think that was the direction of the court.
Okay.
Okay, I think the direction of the court with the most simplistic form is there was already Michael conceded that he wasn't the true owner. So now they're not really taking away his rights. They're saying you're not the true owner. You've conceded it through testimony. You were cross-examined. You had direct examination. You came to court and you never said, I am the owner of this property. It's mine. Actually, on the contrary, he said, well, if it's my home, then I'll pay for it. If it's my home, then I'll pay for it. So what easier than the court to say, okay, the only thing I have jurisdiction over is marital estate. And this is an asset from a marital property and I have to distribute it. She did. She said, wife, it's yours. Now, what she did was give him the opportunity, because I will tell you, there's a reason why we didn't even try to bring Michael in as a third party, because mom didn't want that, right? They don't want their kids
Well, of
involved in
course
cases.
not, yeah.
So the point is giving that
Which is rare, I would add, as you probably know if you practice in this area.
I do. And
there are many people who have no problem whatsoever bringing their children who are a lot younger than this gentleman into court.
But the family's been involved with a lot, and they were, they struggled, and now they're grandparents. So she's still not going to, what I could say, rock the boat with that. She's never going to kick Michael out. She's going to have him make that decision. And to this day, it's still the case, right? But the reality is, and that's why there was questions about what do you do for a living? And Michael at some point said, hey, I don't want to answer that. Well, I'm a pharmacist. My wife's a pharmacist. The judge was trying to establish that you can afford to leave. Your mother can't. Your mother doesn't have a business. She's never worked a day in her life. She purportedly worked at your dad's construction company, but she didn't. So I think the court was equitable in that sense. The court did come to some sense of equity, and I think they did not take away the rights. The last thing I'll say, because I have a problem with the standing issue. I don't believe that Gary in front of this court has standing to fight on what they believe is the infringement of Mike's rights or his constitutional right to even due process. He wasn't a third party. Michael, she took away his interest. What does Gary have to do with that? Because I have one question. Even if the appellant asks this court to remand, what is Gary going to get out of this? Nothing.
Well, I think
he's not harmed.
I think that's an excellent question. I don't think he has standing to complain about what the court did relative to Michael.
And okay, I have nothing said. That's
the court doesn't have jurisdiction over Michael, and Gary doesn't have the standing to raise an issue about what the court did with Michael, because the court, she created a heck of a mess here that could have been easily avoided. Sad, but
we're here.
Yes.
I have nothing further unless you have questions.
Was very well briefed. Thank you very much by both parties. And thank you both candidly for doing it in a very professional manner and not trying to claw each other's eyes out. That's greatly appreciated.
Thank you. Thank you. Thank you very much.
Thank you, sir. Rebuttal?
Yes, just very briefly. I think if we're looking at how courts can ever have the authority to address ostensible or alleged interest by third persons, it's only where you're dealing with certain already articulated, not on the basis of equity for that particular determination in terms of the property interests of third persons, but on the basis of clearly delineated reasons, which are concealment or working together, collusion with one of the parties in the case. Those are the exceptions that break the wall.
Right.
That break the wall between a party that's the court has jurisdiction over the divorce case filed by the parties, or the party's divorce case, and when they can go in and say, this party worked with this third party to hide assets. We don't have that here. We have this here in a case where the quitclaim deed was done in 2020. I set out in my statement of facts that there was more than just the fact that the condo associated needed someone who was on the title to live there. It was consistent with what this family did. The family did give the property of West Village to Michael, and he used that, and it was voluntary. When a father talks to their adult son and said, "Listen, you should give some money back to mom." Well, children are going to do that. At least children in the families I live in. I mean, this is just dealing with immigrant families, but I think we're obligated
I
to our
grew up
children
in an
until we
immigrant
die.
family, so
Yeah,
I-
yeah. I think you're obligated to your children until you die and afterwards. And I think children.
And afterwards is probably, and as a child, you're obligated to feel guilt for the entirety of your
No,
life as
I
well.
don't think children have the same obligation to their parents, only if they feel that they should do it. And I tell my kids that all the time. I said, what we owe is to you. You don't owe back to us. So, but anyway, but that's totally off the point. But
Which
anyway,
makes
it
fun
doesn't
to
fall within,
discuss.
the cases cited by Applee saying that the court had authority don't apply equity, and this case doesn't fall into those cases. The court didn't have the authority, and where it falls into the overall equitable analysis that we don't know how the judge or the court may have come up with it, is that plaintiff received the value of all of that property, at least on paper, and that further skewed that equitable determination that that wasn't really set out by the trial court. So I think that's how it affects Mr. Sleeman's interest. I think he has, if in terms of plaintiff's specific legal interest in that property, I think he would have some interest in that, possibly to be decided by the trial court on if there is going to be a remand, and based on equitable considerations between the two parties. And in terms of standing, with subject matter jurisdiction, it can be raised at any time. So is it a standing issue? It can be raised to a sponte by courts. But I do think he has standing because it affects, we raised other issues too, but it affects the overall equitable division here. And he would have an interest in plaintiff's interest in that property. And that's not an interest, that's not ownership of the entire property. Finally, I think trial
Does
courts
he have to be a party counselor in order for the court to have jurisdiction, or does it simply have in-rem jurisdiction over him?
I think in terms of coming up with any decision on Michael's interest, I
Yes.
think that was my discussion of the cases that allow a court to address whether a third party really does have an interest when there's collusion, when there's fraud, when there's concealment. That was the opposite of this in this case. These parents made this decision together. They were married. They claimed that Mr. Sleeman controlled. I think he was doing what he thought to support his family, and it was a joint family decision. They did what they did with their other son. They did what they did in terms of West Village. They did what they did as a family in terms of this property. And I think things changed once plaintiff finally felt that she couldn't keep living, probably for so many reasons in this tragic case, that she decided to file divorce, and then it became an issue in the divorce. I think the original decision was his. And I think if that decision has to be made, who has an interest, it doesn't fall into the case law that allows a divorce court to invade or to make that determination, but it would be a decision for a separate court to decide title.
Anything further? I have a very quick question for you that does not have anything to do with the case that you just argued, but I have two premier domestic relations attorneys before me, so I'm going to ask both of you, is there an issue in domestic relations law right now as to what does and does not constitute a final order for purposes of appeals of right?
Oh, yeah.
There is.
Okay. I mean, are we talking about the grandparenting time cases?
No, just in general.
Okay, sure. Post-judgment, pre-judgment. In my little group of family law appellate attorneys, We've always felt that any modifiable order should be appealable. The orders in that come after motion to modify a previous order should always be appealable by right because they echo what happens under subsection 7202-6AI1, where you have a trial court making factual determinations on all of the relevant elements that go into a final order. When you have a modifiable situation, you're modifying a previously existing order. You have, in a sense, a new factual situation. You have new facts coming up before that trial court. And in that situation, the trial court makes a new determination that's akin to a final order. So we think if we're everything being pure, that those decisions, an order modifying a previous order or denying modification, well,
Is an award for noncompliance with a court order a form of contempt?
does that depend on?
Not relevant to this case.
So in other words, is that
We're-
appealable by right?
Right, unfortunately, we don't have good lawyers to talk to, so we're asking you.
That's a really interesting issue with contempt. I mean, it's.
Would that
Can
be
you have them
something that?
rebrief? Could you order the attorneys
Yeah,
to rebrief?
would that be something that the section would like to
Sure.
chime in? Okay.
Yes, actually, yes. Okay. But grandparenting time is also an issue that affects, well, anyway, I'm not going to go into the post-judgment
Gotcha.
orders.
No, that you answered it. I appreciate it. Do you have anything to add?
Right, yeah. I mean, so not looking at the final order, just whether, an award under MCR 3.206 for noncompliance with the court order itself is contempt. And then I think we have another case, Tadajewski, about whether the civil contempt order is final order.
You think it would be something though that the domestic relations section would like to chime in on at some point and tell us what they think?
Can't say this is final order now. Right, like property there.
Right.
You have to apply for leave because it's not final order. Right. So the underlying order that you violated was appealable, right, as a final order. But when you violated it and the court orders, filed contempt, then you need to apply because that itself is not a final. Right.
Thank you both. Sorry you can bill me for your services, but obviously I value your opinions and thank you very much for sharing. Yeah. Unfortunately, they're young and not experienced yet in the ways of domestic relations. They still believe that marriage is a good thing.
Oh, I just raised my hand, but could you ask the sections for amicus briefs?
Yes, we
The
do.
Supreme Court would issue an order, and we
Yes,
had
we
a
can.
seminar on that about, and I think it was Judge Frank Kelly who said we should start, maybe the Court of Appeals might want to start doing.
Yeah, that's what we're planning to do. Yeah, she was actually our only domestic relations person, and she's obviously been retired now for a little bit of time. Thank you again, both very, very much. That brings us to item number 11, case number 374502. Bellestri versus Williams. Bellestri versus Williams. I don't know. Did I say it right? Bellestri. There we go. Good afternoon. How are you?
Good afternoon, Your Honor. Rebecca Haynes appearing on behalf of the appellant Olivia Balestri.
Go ahead.
Thank you, Your Honor. This time I'd like to.
Have you
reserve some-
enjoyed listening to all of the cases today?
I have.
No,
actually-
you didn't.
I have. I've been practicing for quite a while, but I've actually never been here. So let's say nice experience, to be honest.
What's your takeaway?
Um,
Bring your hearing aids if you wear them. Should be one.
Bring your hearing aids. Always read your cases.
Yes, yes. At least we didn't get the secretary did it excuse. That one's worn a little thin.
We used to have an ear trumpet, you know, those things down here, but apparently the
No, they wouldn't let me bring it through
maintenance guy
security.
took it
I'm
away.
sorry.
Check whether the cases exist in the correction for citing cases that don't exist.
That was particularly interesting. I'll say that.
Exactly.
Not sure we should repeat the mistake that we're already apologizing for doing, but that's.
All right, so here we're dealing with an employment situation, obviously. And go ahead.
Thank you, Your Honor. This is appeal from a summary disposition order that was entered pursuant to Michigan Court Rule 2.116C7 prior to Appellee Costco filing responsive pleadings and before any meaningful discovery was taken. This case presents a fundamental error. The trial court denied Costco's motion under MCR 2.116C8, indicating that the well-pleaded allegations did state a claim, then subsequently dismissed those same allegations under C7 by demanding corroboration. This is the wrong standard. Specifically pursuant to Morello versus McDonnell Douglas Capital Corporation, in reviewing a motion under MCR 2.116C7, the proper standard is to accept all of plaintiff's well-pleaded allegations as true and to construe them in the light most favorable to the plaintiff. Furthermore, the motion must be denied unless there is no factual development that could provide a basis for recovery. In this particular matter, Appellant Balestri's amended complaint coupled with the affidavit provided, as well as her response to Appellee Costco's motion for summary disposition, show that Appellant Balestri was subjected to unwanted sexual conduct or communication and threats to her employment during the 3 years prior to the filing of her complaint. As such, Appellee Costco's motion pursuant to 2.116C7 should not have been granted. We respectfully request this court reverse that order and remand for further proceedings. With respect to the hostile work environment, again, the wrong fact and the wrong standard was applied here. In the trial court, the judge determined that because Williams did not work in the same physical building as Ms. Balestri during the relevant time period, there couldn't possibly be a recovery under hostile work environment. That's not the standard. In Michigan, there's zero requirement that the individual have to work in the same physical location to support a hostile work environment claim. The proper analysis under Radke v. Everett specifically states that under the totality of the circumstances, the work environment is so tainted that a reasonable person in plaintiff's position would have perceived the conduct as substantially interfering with employment or having the purpose or effect of creating an intimidating, hostile, or offensive employment environment. There's nothing in the Michigan court rules, or I'm sorry, nothing in the Michigan case law and nothing in the statute that again restricts that environment to a single physical location where both employees are at every single day. Therefore, the trial court's geography test is not the proper law here. Again, under a C7 standard, this is just whether or not the allegations were pled that show during the relevant time frame, Ms. Balestri properly pled a claim of sexual harassment for a hostile work environment as well as quid pro quo. With respect to the hostile work environment, she specifically stated during the relevant time frame that Williams conditioned her continued employment on a sexual relationship, that she reasoned to believe those threats. The complaint has a very detailed background specifically to identify that Costco was on notice, that there were prior issues between Williams and Balestri, that there was prior physical conduct or contact between Williams and Balestri, and that there was an ongoing issue. He resumed those issues pursuant to the facts as stated by Balestri in her complaint, starting in December of 2018 and proceeded well into April of 2021, again, well within the relevant time period.
Can I ask a question at this juncture? Let's suppose hypothetically that the facts are laid out as in a manner that you say they are, and for purposes of appellate review, we assume that they are. And again, my apologies. Sometimes the cases kind of get them all mixed up, but in this particular case, it seems to me that on the issue of whether there was a quid pro quo sexual harassment, that those actions may be outside the statute of limitations. Could you address that for me, please?
Absolutely, Your Honor. The issue with respect to the quid pro quo and whether or not Williams was directly a supervisor or within the line of her managerial effect, that's a question that needed to be that should proceed to discovery in order to fully flesh out. It requires further factual development. After Costco claims that he was moved to another warehouse, Ms. Balestri was still continuing to receive threats that he could interfere with her paid time off and other aspects of her employment, including whether or not she remained employed. He had a lot of influence with the other supervisors in that area, specifically pointing to the fact that his own girlfriend, which Costco knew that Ms. Ferguson and Mr. Williams, as again as alleged in our complaint, were in a relationship. How was she even able to be placed in a managerial role over Ms. Balestri? There's a lot of questions that require further factual development to determine exactly what Williams' relationship was in respect to Balestri and her chain of command.
Well, we do know when he was moved, correct?
When he was moved to a separate location, yes, Your
Correct,
Honor.
yeah, so we know that. But your client's contention is that that was irrelevant to her claims of quid pro quo harassment, because even after he was moved, he continued to engage in similar activities, correct?
Correct, Your Honor, including continuing to condition her employment on this ongoing sexual relationship with him, which culminated in February of 2021, where he used that specific statement, "Come to my house or you'll be fired." I am paraphrasing, based on the complaint, to lure her to his home, where then, very unfortunately, she was assaulted and raped in a horrible way.
He's in prison, isn't he, for that offense?
I believe he is still incarcerated, yes.
All right, thank you.
Thank you, Your Honor. And then, again, with respect to quid pro quo, again, under the statute, there is actual no no requirement that the individual be a supervisor, just has to state that they have to have the ability to have a tangible effect on the individual's employment.
But that's not an issue here. He was a supervisor, right? And your complaint alleges that he used his powers as a supervisor and his contacts within the corporation to make it appear to your client that he had direct authority over her, either through himself or through acting through others.
Yes, Your Honor. And again, the standard that we should be looking at here is under MCR 2.116C7, which has to take all of those well-pleaded facts as true. And in doing so, under the complaint, appellant clearly pledged she was subjected to unwanted sexual harassment that had tangibly impacted her employment between December 2018 and April 2021. It's undisputed that Williams remained employed in a supervisory managerial role at Costco during that time. And further factual development is thus merited into whether Williams is considered a supervisor empowered by Costco to take tangible employment action against appellant. And because of that, granting the motion pursuant to C7 at the lower trial court level was improper.
Can I ask what level of proof you believe you need to have? For example, if I say to you that I am your supervisor and or that let's assume the same thing happened, but now I'm not your direct supervisor. Are you telling me that case law permits a finding by a jury on quid pro quo? Not talking about setting aside, let's let the emergency vehicles, not my day with interruptions. It just isn't. Putting aside the hostile work environment pertaining now just to quid pro quo, what case best illustrates the idea that an individual can engage in quid pro quo hostile excuse me, quid pro quo sexual harassment by claiming that they will act through others within the corporation. Do you have a case that's directly on point on this issue?
Well, Your Honor, that I think it's, with all due respect, I think it's the wrong question with respect to this exact issue because we are
Okay.
just trying to get past the pleading stage into discovery. That would be a much better question suited to a motion before this court on a C10 or even a C8 issue where we're looking at whether or not there's a genuine issue of material fact in applying the law.
I understand that, but as a matter of law, I just want to know, do you have a case that says that an individual who makes threats in exchange for sexual favors, but does so through claiming that they can manipulate others who may be in a position of direct supervisory authority over your client? Do you have a case that says that or not? Or not at this juncture? Is that what you're telling me?
Your Honor, with respect to that, I do believe that there is no current published case law in Michigan that would,
Okay.
that has made a decision on that. And again, all of the cases that discuss that have been brought before either this court or the Supreme Court on much later stages, either after trial or on a C10 standard, which again is not the standard that we are looking at today. But regardless on that, that
But if
theory
you're
would be-
making a, my point is this, I don't want you to miss my point, is if you're contending that there is legal authority, then now would be a good time to tell us what that legal authority is, right?
I agree
There's
with you, Your
legal
Honor, that's-
authority to support this claim, and here it is. But I understand if you don't have a case directly on point.
Your Honor, there, again, I'm not aware of a case that's directly on point.
Well, I
However,
appreciate your candor.
however,
you.
again, under the statute as well as, Your Honor, I know that the beginning of the case name is Salinas. I do not have the full case at my fingertips at the moment. However, it's the case that indicates that that an employer is vicariously liable for a supervisor's actions once they know that that supervisor has engaged in specific conduct that would give them notice that, for example, in this case,
The person have to be a supervisor or have tangible authority. It's not just enough that you.
that's correct, Your Honor. And again, at this juncture, it's not the proper standard that we'd be looking at to simply overturn the motion for under C7. However, in following that, the case that you are referring to, I do believe in that case it was merely a belief. There was no facts in that matter that would show that there was any merit to that belief. Here, we do actually have Williams in the past interfering with her employment, using supervisors to deny paid time off, scheduling paid time off so that she wouldn't be able to say no to go on vacations with him. There is actual evidence that he did use his managerial and supervisory powers.
Any questions? I don't think so. Would you like to reserve the rest of your time, or do you have further argument?
I believe at this time I'd like to reserve the remainder of my time.
Thank you. Thank you, counsel. Good afternoon.
Your Honors. May it please the court, my name is Sarah Fowler and I represent the defendant at Pele Costco Wholesale Corporation. Your Honors, the question here is whether there's a timely claim against Costco to be held legally liable for sexual harassment by Brandon Williams after December 1st, 2018, in the absence of any work relationship or connection between Mr. Williams and appellant. And the answer is no. This court should affirm the dismissal of appellant sexual harassment claims against Costco as outside the statute of limitations because 1, Brandon Williams had no authority over appellant to premise a quid pro quo sexual harassment claim, nor was there any tangible employment action taken within the limitations period.
Is it your contention that as a matter of law, he needed to possess such power to be found responsible on a quid pro quo theory?
Absolutely, Your Honor. And number 2.
Do you have a case that says that you can cite to me?
Yes, Your Honor. Michigan
Go ahead.
case law is very clear that someone does need to have authority to take tangible employment actions in order for there to be quid pro quo liability. Chambers versus Tretco, for example. We also cited Hammoud versus Trinity Health Corp case in our briefing, where they held that merely believing someone had the power to influence or affect their employment was not enough to effectuate a tangible employment action here.
Is that what you think happened here? If we flesh out the claim, so to speak, that it was the opinion of the plaintiff in this matter that this fellow may have had some authority over her after your client had removed him?
Your Honor, taking appellant's allegations in her amended complaint, the affidavit, as true as we must for the purposes of this C7 position, that may well be what appellant says she believed that, but Michigan case law must control here. The law is very clear that appellant's belief or assumptions about Mr. Williams' authority is not enough to premise a quid pro quo claim. And
what if he says what he said? Oh, my goodness, it's been a long day. Apologize. What if he said what plaintiff claims he said? What if he did say to her, I know Joe Blow, and all I have to do is tell Joe Blow to fire you and you're done?
Your Honor, again, so one, to the question that you were posing earlier, there is no legal authority that either party has cited that we have been able to identify that says having influence is enough to establish a quid pro quo sexual harassment claim. And in that case, Mr. Williams did say that. And one of the appellant's supervisors or managers who she did actually work with within the limitations period did something to her. Maybe it would have been at Mr. Williams' behest. That may give rise to an actionable quid pro quo claim. Theoretically, that's not what we have here. We have no tangible employment action taken during the employment period. And there is no allegation or evidence that Mr. Williams did actually do anything to anyone with who appellant worked with within the limitations period. But this dispositive issue truly is the lack of authority here. And there is no fact dispute here about Mr. Williams' authority over her employment within the limitations period. He was demoted to an hourly supervisor position in August of 2018. And if the court looks to, as part of the record, if it cares to look to pages A51 and A52 of the record, which are the business records that Costco submitted in connection with its motion for summary disposition, it shows that Mr. Williams was an A2 full-time hourly employee, the same category that appellant is identified as, throughout his employment after 2018, except for an 8-month period between February 2020 and October 2020. So as of February 2021, for example, when Mr. Williams told appellant to come to his home, he was in the same hourly category as she was, that A2 category at that time. And we know from appellant's own allegations in the complaint and in her affidavit, it is clear Mr. Williams was outside, to use her terms, chain of command throughout the limitations period. So influence alone is not enough here to effectuate any changes over employment positions. He had no authority over her employment within the limitations period, and there can be no quid pro quo claim on these facts as alleged, and even with the affidavit submitted.
Does the same apply to a hostile environment claim?
I think the issue of authority is still very relevant to the hostile work environment claim, but that in itself is not as clearly dispositive as it is in the quid pro quo context, Your Honor. So I'd be happy to address the hostile work environment
Go
claim.
ahead, if you would, please. Thank you.
Your Honors, this court should affirm the dismissal of the hostile work environment claim as well, given the absence of actionable conduct within the limitations period, because appellant cannot show she experienced a hostile work environment based on sex within that limitations period, where she did not work with Mr. Williams and had no work-related interactions with him. Now, appellant argues that there is no inherent requirement in the Civil Rights Act that harassing conduct must take place at work, or that she and Mr. Williams had to work together. And that's true. And Costco does not claim that harassing conduct can only occur within the four walls of the workplace.
Or in your client's case, the mini walls.
The mini walls, yes, the aisles, and yes. But Michigan courts nonetheless make clear that there still must be a connection to the work environment. The workplace must still be impacted. And so counsel cited Radke in her remarks. The Michigan Supreme Court in Radke and in Elizavich framed the hostile work environment analysis as being actionable when the work environment is tainted by harassment or when the harassment occurs in the workplace. And in the Heidish versus Hungry Howie's case that we cited from the Michigan Appellate Court, in discussing how out-of-work conduct did not give rise to a hostile work environment in that case, it italicized those very words in citing these Michigan Supreme Court authorities, that the employment environment, the work environment. And this underscores that Michigan courts look to the work-related connections and impact in determining whether a hostile work environment exists. Now in Heidish, the Michigan Court of Appeals held that conduct alleged by appellant that her godfather, who was the owner officer there, could not support a hostile work environment claim under Elliott Larson because none of those alleged actions happened within the workplace and the owner officer was not involved in the day-to-day operations where the plaintiff worked in that case. It noted that there was no evidence that the work environment was affected, despite the appellant or the plaintiff there providing evidence that she was uncomfortable in the workplace because of what was happening outside of the workplace. And it rejected the argument that that could establish a hostile or offensive work environment. And the court said, alleged incidents, although clearly harassing, did not take place in the workplace.
What
And
about the
that's,
photos he sent of them?
I'm sorry,
Didn't
what
he
was,
send photos of her to Costco employees?
Your Honor, in appellant's affidavit submitted in response to the motion for summary disposition, she says that in April of 2021, Mr. Williams sent photos to her family members and to her coworkers. There's nothing in the record or in the allegations that she ever told Costco about that allegation. So even to the extent that that single act in itself could constitute a hostile work environment, and that's not, we don't concede that it does, but there's not a basis for respondeat superior liability based on that single act where there's no allegation that that was ever reported or made known to Costco. And as the trial
Oh,
court,
if it was sent to Costco employees, what more do you need?
well, it doesn't identify who Costco employees were. So if it was sent to certain coworkers, again,
I mean,
that has,
it's an affidavit in response to a C7. And why is that not enough?
well, that was why the trial court was asking appellant very strenuously during the hearing, what is the evidence? What is the evidence that anything occurred that was actionable within the period that we're talking about here? And as the trial court said, and it's an unfortunate reflection of where we are in this time, I think, as society, what he did was not via his employment at Costco either. So anyone can unfortunately send messages, text
But if you
messages.
send it to people at work, I mean, that's certainly affecting somebody's work. And she says it in her affidavit, and we rely upon the affidavit pleadings in a C7.
Right, and the pleadings, it was, and there was a claim against Mr. Williams in the underlying proceeding for that. There's no mention of that being sent to Costco employees, and that was added to the
But it does
affidavit.
in the
Yes,
affidavit,
yes.
and we consider the affidavit.
Of course, Your Honor,
Okay.
yes. And at that time, appellant was not working at the Commerce Township warehouse. She was working at a different warehouse, the Auburn Hills warehouse at that time. It doesn't explain who that was sent to, how that impacted the work environment. And again, there does need to be notice to an employer in that instance. And here there's nothing to suggest in appellant's affidavit or allegations that there would be something to put Costco on notice of, that it's sent to a manager, for example. The affidavit provided details on specific manager names in other instances. Here, there's nothing to say who that went to, how that impacted the work environment, and then for the basis of respondeat superior liability. And so just briefly again on this issue of having the work, the impact on the work environment, and Heidish again saying these incidents were harassing, but they're not in the workplace harassing. And Michigan courts contrast that, for example, in the Parker versus Plastipac case that we cited, where it said off-work, off-premises conduct by a coworker cannot be fairly attributed to an employer, nor can it fairly be said to be the fault of the employer. But in that case, of course, we have someone then coming into the plaintiff's workplace in Parker, lurking around, engaging in misconduct in the workplace. That was a basis for hostile work environment. Here, there's no dispute that Mr. Williams never worked with appellant. There's nothing to say that he ever came into her workplace at all within the limitations period. All we have is that off-work, off-premises conduct that Parker said is not actionable and not the fault of the employer. Counsel brought up, referenced the Genesis versus, or Salinas versus Genesis Health case, I believe, referencing earlier in discussing Costco's liability for the criminal conduct that Mr. Williams engaged in within the limitations period. And so I just wanted to briefly note regarding that case that was cited in their appellate brief, or sorry, their reply brief. And that citation was a quote from Champion that said, when an employer gives its supervisors certain authority over the employees, it must also accept responsibility to remedy the harm caused by the supervisor's unlawful exercise of that authority. And so interestingly, in the Salinas case, it rejected that Champion applied there, said that that quote was not applicable and it wasn't a civil rights case. Michigan courts have not adopted the aided by the agency exception to the restatement of torts. And so the fact that an employee may have had an opportunity through their employment to commit a tortious act does not give grounds for liability. And here the record does not show that Costco gave Mr. Williams any authority over appellant and specifically removed him from her employment outside the limitations period. And so under Michigan law, appellant's argument for respondeat superior in that situation fails. And so again, circling back to the hostile work environment claim, it's Costco's position that here, in the absence of any work-related interactions, any connection to the workplace within the limitations period is dispositive given the prior Michigan court cases that have examined these issues.
I thought that also there was a contention by plaintiff that when she reported Williams' behavior to her supervisor, that supervisor told plaintiff, if you say that again, I'll fire you, or something to that effect.
I believe what Your Honor may be referring to was from the outside the limitations period, August of 2018
That's what I was going
allegations.
to ask. Is that outside of the limitations? All right.
Yes, I believe those allegations were when she initially reported Mr. Williams' conduct in August 2018. Costco investigated and then removed him from the workplace. But that was something she attributed to the manager at that time.
Interestingly, didn't terminate him. So I don't know what you need to do at Costco to get terminated, but that's not at issue here. But you know, this stuff has a tendency to boomerang back on you.
And Your Honor,
and I know as a lawyer, you don't advise them not to. You don't say, "Hey, let's keep all of these people because it's a good idea," although you know it gives you work. But candidly, it just seems as though there was sufficient evidence at that time that would have justified removing him. But again, that's neither here nor there.
and again, outside the limitations period that we're discussing here today, but certainly again, having removed the two individuals from having any work relationship with each other, that is a dispositive factor here when we're considering whether when appellant comes to work, she is experiencing a hostile work environment because of sex. Counsel raised the notion of having Mr. Williams' then girlfriend be her supervisor within the limitations period. There's nothing to suggest that that is improper to have someone who's also having a dating relationship be that supervisor. Be that as it may, appellant concedes that when she reported to Costco that she was having an issue with Ms. Ferguson, Costco removed her from appellant's chain of command at that time again. So nothing to establish a hostile work environment based on sex or employer liability for that act within the limitations period.
But I think in her affidavit, she named 6 supervisors by name, right? Some of those were within the statute of limitation period, right?
So yes, Your Honor, appellant.
These weren't wild. I mean, she names names of what she said to about 6 supervisors that this guy was threatening her job if she didn't have sex with him.
Yes.
Why is that not enough?
Well, Your Honor, number one, we still have to establish that there's a hostile work environment, that prong 4 of the hostile work environment analysis before we get to the respondeat superior analysis in prong 5. So it's Costco's position that, again, we lack a hostile work environment first and foremost, even if she reported the threats to her employment that she alleges in her affidavit that she did. So, but moving then to that respondeat superior prong, yes, appellant claims in paragraph 18 of her affidavit that she reported Mr. Williams was threatening her employment if she did not engage in a sexual relationship with him, and she identified those specific individuals. And so appellant is claiming that she's told her supervisors and managers that someone, her ex-boyfriend, someone who she did not work with and had not worked with for 2 years, who had no authority, no oversight over her, who did not work in the building, was threatening her employment. In the affidavit, it did not claim that appellant reported any impact to her work environment, that anything was happening to her in her workspace for Costco to take action on specifically there. The affidavit does not allege that there was an impact to the terms and conditions of her employment, on her hours, her wages, her position, her job performance. It again doesn't allege anything about the other acts that she claims took place within the limitations period. And so looking back to Radke, the essence again of a hostile work environment is that it creates an atmosphere so infused with hostility that it alters the terms and conditions of employment. And looking to the hostile work environment standards espoused by Michigan courts, appellant reporting these comments made in the course of the personal relationship with someone who didn't supervise her, while admittedly troubling, that in itself does not establish a hostile work environment. As to the point that appellant makes that Costco then failed to protect her from what she reported, it's undermined by the fact that the terms and conditions of appellant's employment remained undisturbed. There's no allegation that she was ever disciplined, suspended, fired, or that her employment ever was in jeopardy. And the employer's obligation is to remedy what it is on notice of. The remedy that Costco can enact to reported threats to employment is to ensure that appellant's employment is not jeopardized. And there's no allegation or evidence that it was, or that anyone with whom appellant actually worked tried to or threatened to take action toward her employment within the limitations period. And so Costco can control what occurs in its warehouse. It can control appellant's employment status, again, whether she's disciplined in those terms and conditions of employment, what she experiences when she comes into the workplace. And again, Costco took action to ensure appellant had no work relationship with Mr. Williams more than 3 years before the complaint was filed, when it separated them from working together. What Costco cannot control, and Michigan courts do not put the onus on employers to control, is who its employees socialize with outside of work, who they have relationships with outside of work. Its responsibility to remedy a hostile work environment does not extend to protecting employees from domestic abuse situations outside of work. That's properly the province of the personal protective order, for example, which appellant alleges she eventually sought. And when we consider respondeat superior liability for a hostile work environment claim, the ultimate question Michigan courts remind us to consider is it requires employer fault. And here, Costco cannot be vicariously liable for Brandon Williams' off-duty manipulations, as reprehensible as they were, made during the course of his personal relationship with appellant. Appellant does not have a timely claim to hold Costco legally culpable for a hostile work environment for Mr. Williams' out-of-work actions within the statute of limitations period. And the distinction between workplace and private conduct is about defining responsibility. Your Honors, unless are there any further questions as to either the hostile work environment or the
Just
quid pro
kind
quo?
of, that was a soft landing. I was waiting for the big, like a Mahler symphony to really come bursting through there.
Well, it
Just kind of,
I can say that, Your Honors, the Michigan legislature drew a clear line in Elliott Larson. Elliott Larson claims against employers must be brought within a 3-year statute of limitations period. And here, after August of 2018, again, there was no workplace connection between appellant and Mr. Williams, and the statute of limitations appropriately reflects that boundary. And so we ask that this court affirm the trial court's dismissal of appellant's hostile work environment claim, because there was no sexually hostile work environment within the limitations period or basis for respondeat superior liability, and affirm the dismissal of the quid pro quo claim, because again, Mr. Williams lacked any authority to effectuate any tangible employment decision, nor was any tangible employment action taken.
any questions, Judge Kelly?
No further ones.
Judge Ackerman? So you're based in Chicago, am I
But
correct?
I'm a Michigan native, so I'm happy to be
Are
back.
you really?
Yes.
Oh, where are you from?
Oakland County.
Oh, okay. And do you like living in the Chicago area?
I do enjoy it, yes, but it's been great to be downtown and see how things have changed.
Quite a bit, I would
Yes.
imagine.
Yes.
You're very young, but.
Oh, thank you. I'm
I
at the age where I appreciate that now.
I went to school here in the 80s, and so did Judge Kelly. And I mean, we go to dinner places where, my goodness, we would have never dreamt of walking, even in the daytime.
Really
So
wonderful. Well,
it's
excited for the
nice to
Pistons
see.
for tonight. That's certainly exciting.
Oh, you're going to the,
No, but just not going, but excited to see them back.
yes.
Home playoff game.
Yeah. Missed opportunity, but thank you, Your Honors.
Well, call the firm and tell them that we ordered them to buy you a suite for
They
the
might be
pi-
listening. I'll let
And
to see
there
if
you
they're,
go.
yeah.
So,
Thank you very much, Your
well, you
Honor.
did an excellent job and you wrote an excellent brief, and I mean that sincerely. Thank you very much. Rebuttal? And you also wrote a very nice brief, and you've done an excellent job on behalf of your client. I think if we want to look at the long view, so to speak, or the big view, nobody disputes that what happened to your client was an absolute travesty, should have never occurred. The question becomes, on what basis is Costco liable for what happened to your client?
Yes, Your Honor, I understand that. If I may address some of the arguments brought up by the appellee or counsel for the appellee here. Specifically under quid pro quo, she mentions repeatedly that there was no actionable, that there's nothing actionable done to Ms. Balestri's employment.
Do you mind if I interrupt you real quickly? This is your first time in this court, so let me just give you a piece of advice. When the judge asks you a question, and to quote George Bush, we're the decider, you might want to answer the question first and then go. And I mean that in all sincerity and in good faith, but you know, I think the issue that you have here is twofold. Number one, relative to the quid pro quo, I think you have a statute of limitations problem. So relative to what sister counsel said to that, I would direct you to address that. Why don't we start there, if that's all right with you?
Yes, Your Honor. Again, whether or not Mr. Williams was in the chain of command and had the ability to make tangible effects to her employment remains a question that needs to be discovered with further discovery. Yes, some records were produced. However, there was no depositions that were ever permitted. There was no ability for appellant to receive further questions on exactly what that employment designation was and what he was permitted to do.
Well, help me out here. Best case scenario for your client, what's going to happen at this deposition? That's going to give your client a case outside of the statute of limitations relative to quid pro quo.
Your Honor, he remained a supervisor well into 20, or at least from if you're basing everything on what our client has stated, he remained in a supervisory and managerial role. He had the ability to make these concerns, whether or not he had the ability with respect to appellant and whether or not he could actually move forward on that, again, is something that we would need to explore in discovery and deposing the proper people. That was not permitted to be done in this case before this motion was heard and before the motion was granted. And again, whether or not for quid pro quo, it's not whether or not it's an actionable offense. The statute clearly indicates that predicating the acceptance of sexual harassment to make it a condition of your employment, which is exactly what Williams did here, that in and of itself is sufficient to satisfy the standard.
Hypothetically, assume that you come to work for me here at the court. And well, not me, but you come to work somewhere. What's Costco's right? Sam's Club. You go to work at Sam's Club and you begin dating your supervisor and you have a relationship with that individual, and then things go south, so to speak, and that person is removed and you continue, but that person continues to say, if you don't have relations with me, I'm going to make your life miserable at work. Do I have even the apparent, or that person have even the apparent authority to do anything to you relative to your work?
Your Honor, in that hypothetical situation, there's again a lot of facts that would need to be fleshed out.
Such as,
again, whether or not that person does have the authority to do so, to interfere with shifts, to constantly be threatened termination for somebody who really needs this employment.
let's suppose, as is the case here, that I do not directly have the authority to do anything. But I do possess the authority to tell my friends who are in supervisory positions over you to do something. You're telling us that that's sufficient, correct?
Your Honor, at this time, I'd have to concede there is no case law in Michigan that does permit that, but there also is no case law in Michigan that specifically has rejected that theory as well. It's just at this time, it has not been determined in the state of Michigan whether or not that is. However, the
But that's kind of my point is even if you can prove it, what is it that you've proven? Do you follow what I'm saying?
I do.
I don't mean, I don't mean that in a demeaning way at all, but let's suppose hypothetically that we go to this deposition and Williams says, yep, I had the authority to do things to her because I could call John Doe and John Doe would do whatever I said. Now you think you have a quid pro quo, you'd have a
Quid pro quo,
claim.
Your Honor.
Right?
Okay, it's been a long
And
time.
I would say, regardless of published case law, I'd be willing to say you have a claim. I'd be willing to say, as long as you felt that and that you had the authority. But now, let's assume that's true. Sister counsel then makes an additional argument, and that argument is, what knowledge of this did Costco have? And I guess to you, my question would be, does Costco need to have knowledge of this in order for them to be vicariously liable?
Under a strict quid pro quo claim, no, they would not
It's,
have.
sorry.
Jumped over here. Under strictly that, they would not. However, under a hostile work environment, they would. But again, that's not the question here because they did have knowledge. Ms. Balestri did report Mr. Williams to 6 different supervisors and managers between 2020 and 2021. They were well aware of what he was doing, and there's absolutely zero evidence in the record of what was done after those complaints were made. Additionally, they had continuing knowledge of Williams' conduct that ran into the statute of limitations. So whether or not Costco knew what Williams was doing is not a question here. They absolutely knew what he was doing.
Okay.
Um,
Thank you. Now, I interrupted you, so any additional arguments you want to make, feel free, counsel.
Thank you, Your Honor. Again, just tying for the hostile work environment back into the workplace, he repeatedly conditioned her employment on accepting his sexual advances. And just to distinguish some of the cases indicated by sister counsel here, especially with Haddish, again, in that matter, it's unpublished and involved harassing conduct that was unconnected to plaintiff's day-to-day operation, whereas here, Williams was admittedly a supervisor in a managerial role. With respect to Parker, that case specifically recognized an exception that an off-duty conduct can support liability where it follows the employee into the workplace. That specifically occurred where Mr. Williams distributed sexual photographs of Miss Balestri to her coworkers. So that conduct absolutely did follow her into the workplace.
So would it be fair for me to extrapolate from those remarks that the dissemination of photos, I assume nude photos, of your client was something that affected her work?
How could it not, Your Honor? It
Well, I'm
absolutely
asking,
would.
right? That's your position.
Yes, Your Honor. That's one
Okay.
of the issues that tied it back to the workplace. It's the most obvious one that ties it back to the workplace.
And he had their phone numbers because he worked at Costco or however he sent the stuff on. And
Yes, Your Honor.
basically, I mean, all of your allegations, except the photos, because there's proof of that, might collapse in discovery, right? But you're saying this is C7 pleadings, affidavit. Is that enough to march forward and smoke it all out in discovery?
Absolutely, Your Honor. We're not asking this court to decide whether or not she would prevail at trial or even whether or not she would prevail on the same motions under a C10 standard. We're specifically asking that her well-pled claims make it past this motion as they were supported by sworn allegations that Costco needs to accept as true for purpose of this motion, and that it be allowed to proceed into the discovery phase. And again, the motion on C8 at the trial court level was denied, indicating that there was a well-pled case here. Therefore, she should be entitled to further factual development through the discovery process and depositions, which will provide a basis for which could provide a basis for recovery, and that's the standard we should be looking at here.
Anything further? Any questions? Thank you both very much. I appreciated your editorial comment about shows where we are at this juncture. It reminded me, I was handling a sexual harassment case when the Clarence Thomas hearings were going on, and it suddenly became the cause celeb of the legal world, because I happened to be handling something that people didn't know actually happened until that point in time. But to see where we've come from then to now, there has been some improvement, but lots more to come.
You two might have been told about that case in your third grade class.
I don't know if they were even born yet. Thank you both very much. Appreciate your arguments and your submissions. Have a safe journey.
We went to high school together.
Oh, okay.
All right.
What can you tell us about them?
We're about 3 class years apart.
Well, now you gotta go.
I've heard about it.
Nah, he's free.
It's just right across Woodward, whichever direction Woodward is.
He's free. He can be there. What time?
I believe it starts at 6 at the,
You writing this down?
I'll work it out. We were at the same table for the alumni fair,
Oh,
which was
okay.
really fun.
Where did you go to school? Pardon? Cranbrook. Oh. Okay. Well, thank you again. I think that's the last oral argument. So I will call the rest of the remainder of the call. Item number 12, case number 377-690 in Realis Minor. No one is endorsed for oral argument. That matter will be submitted on briefs. Oh, excuse me, one person was endorsed. I don't see them here. I assume they have not shown up. Last case is item number 13, case number 372-519, Inway Childress, minors. No one has been endorsed for, or excuse me, Inway Childress, not minors. No one has been endorsed. Court is adjourned. Thank you.